That's all. So you apprehend that 2 to 5 will collude with appellant and concede in the writ appeal petition and allow the court single judge will allow the writ petition. That's why your presence is necessary, right? What? Yes. Appellant, full stop. The appellant therefore made an application seeking his impleadment, which has been rejected by the learned single judge by the impugned order.
Delocalized.
The present application filed, agreed by the order passed by the single judge. The writ was filed questioning the amount quoted in the demand notice for regularization of house site plot as per GOMS number 59 dated 30/2014. According to the
You are encroachers, right? You are encroachers of the land, right? What fundamental right do you have or any statutory right to seek regularization on the terms you want?
No, it's not.
You should want free of cost should be given to me. How can we? This is which law says that it should be at the 20%, 25%, 50%, 100%? What is it?
It is the GO. It has been they have.
No, we are not inclined to take a view in favor of encroachers.
That they are in long-standing position.
No, long-standing. This is we don't want to put a don't want to give an impression that law puts a premium on this dishonest conduct of encroaching the public property.
The second.
What is the title? You should be thrown out. They are they are magnanimous enough to do all this thing, whatever for extraneous consideration. That's a different thing. But it's a public property. Can't be like this thing encroached and this thing, and you are fighting litigation.
May I submit? The other aspect.
You may argue whatever. We were told you the crux of the matter. We will. It's not that, Mr. We will not hear you. Please go ahead. Now argue whatever. The crux of the matter we have told you. Yes. Go ahead. That it is arbitrary, 25% basic value should be paid, and they are charging excess, all this.
25%, it's not, we are not questioning the 25%, they have calculated, suppose 245 square yards is there, and in 245 square yards, a part of the land is covered by the structure and the remaining part is open land, Now for the open land, they have quoted 100% of basic value. And for the structure that is existing, the only 25%, and there is nowhere stated so, in the GO that the open land surrounding the structure is to be charged with the full basic value, So that is the grievance, we have, in the order, it has been quoted, page 40, 50, page 50. Out of 245 square yards, 133 square yards is the area covered by the structure. So therefore, they have calculated 25%. And for the rest of the land, they have quoted 100%. No, GO doesn't say so. That's making a lot of difference in the amount. That's it. And the second aspect is, according to the GO, GO number 59.
So levy is not in accordance with GO.
Yes,
that is the grievance.
Yes, that's my grievance.
You hear them and decide.
Check 1 minute.
No, this whether on the question whether levy is in accordance with Geo. That's it.
Is that in accordance with you? I'll just demonstrate before my lordship.
All.
Your lordship, look at 59, page 75.
Page.
Page 75 of the paper book.
Yes.
Kindly see, my lord, your lordship, go to the last paragraph, non-residential portion. Roman 5, Roman 6. Possession of government land as extension or appurtenant to a dwelling unit on land already owned or assigned may be considered for the payment of full basic value. But structures, for structure they were charging 25%, and for the appurtenant land, my lord, which is an occupation of, now, my lords, there are cases where dwelling units are only on 10 square yards of land, 125 to 50 square yards are being now regularized. Kindly see the loss to the state exchequer of. That's how, my lord. But it-
Even in that 10 lakhs, they will not get this.
Yes.
This much below the market value.
Not are in Gachibowli and all those areas, forest land.
My lord.
Learn some backside those.
You would be well advised to pay it immediately. We don't know. Supposing if tomorrow this Geo is rescinded, you will be angry. Fire. So we don't know what happens.
My lord,
You advise your client to immediately deposit, get the order. The present government is doing it. We don't know what happens. Somebody may change the policy, withdraw, then you will be again into litigation.
for a moment, my lord,
as it
this
has
class 6 speaks something
As it
else, my lord.
has fallen from the bench, where I had argued before the Leonard Singh is just saying that they have no legal right to.
No right.
Plus, my lords, the Leonard Judge has
This is-
considered this aspect. They further requested.
No, we see, Mr. Ravi, if they would have come, we would have dismissed the petition with cost, but it's your own policy, you are bound by it, you are regularizing.
They
What
requested,
can be done?
they requested.
And even that amount, they are not willing to pay. They want to contest. They probably want that you should pay free of cost to them and pay some amount to them so that they can construct houses under Pradhan Mantri Awas Yojana, right?
I'll
Just the prayer.
this class, my lord.
Lighter weight, Mr. You can at least smile, right? There's nothing, the case will be decided.
My lord,
The
this
request
class
to
6,
say to maintain status quo for further 6 weeks, saying that the amounts which they have to be paid to realized. 6 weeks time was also granted by the Leonard Singh, there is request.
my lord.
Now they will go northwards, right? The weather is getting cooler there. So
My lord, this class 6 says, my lord, actually, if already pre-warned that these are the words.
no,
used.
Mr. We are this morally wrong and ethically wrong. We are not inclined to. This is, please remember, apart from everything else, even assuming everything is your favor, this is an extraordinary discretionary jurisdiction.
There are
The
other-
fact remains that you are an encroacher and you have no title. We don't want to exercise any extraordinary discretionary jurisdiction in favor of an encroacher. You don't have a right.
My lord, my
You
submission.
reconsider your policy, throw them out. Why this thing? They don't want to pay. You withdraw this and this thing. Issue notices under the Public Premises Eviction of Unauthorized Occupants Act. So throw them. This all shouldn't you, government shouldn't do it. As a model state, you know what is the law. How a public property is to be dealt with. Is this the manner that putting premium on their conduct and these people, they don't want to pay also whatever amount is demanded, you better revoke this policy and evict them under Public Premises Eviction Act.
Lord, there are other, my lord, petitioners, my lord, there are other, it's a common order, my lord, there are other petitioners before the lower court are there, they have purchased the property through registered agents. My lord, I am in one of the petitioners, my lord, but it's a common order, my lord.
No. We lower court, which lower court?
Sorry, my lord, single judge, my lord.
Hey, what is this?
Sorry, my lord.
Not unfair.
Yes. My lord, this
Unfair.
class 6, my lord, actually, in fact, is giving a
Nothing we have understood. I think we have given more time than what the case deserves. We under the grievances, you don't want to pay anything. You want financial assistance from them to construct houses,
my lord,
free of interest, free, not even a loan, a grant. That we will record. That he says that all this should be waived and they should be given 15 lakhs each for construction of houses. Because it's an open land, they cannot afford.
it's not an open land, my lord, structure is there, my lord.
So you should demolish it and build a multi-storied complex, right? the public money, they are willing to do it.
245 square yards.
You can do whatever, build a pakka house and with 2 floors, this thing, he will approve the plan, give money, Mr. Prasad.
And moreover, my lord, the basic value also, my lord, after the filing of writ petition before this.
I think this is all frivolous.
My lord,
We are not willing to do. Everything is in your favor. Even if decision of Supreme Court in your favor, we will not interfere. We are telling you. This is a conduct, dishonest conduct. We cannot put premium on this, encroaching the government land and then saying that it should be given to us free of cost.
no,
Nothing.
we are not seeking any free of.
This is what it is, Mr.
Not that the charges.
Don't, if you can't pay leave, who compels you to stay there? They are not compelling. If you can't pay the amount, go somewhere else. Purchase a registered sale deed. Begin your life by honest means. What is there? Encroaching upon government law. We at least don't expect any indulgence from the court of law. We will not do it. This is an extraordinary discretionary jurisdiction. We are not prepared to exercise in favor of an encroacher. That's for sure. This intra-court appeal is filed against an order dated
if I am already pre-owned or already assigned, and if neighboring, if a government land is under encroachment for that, Milord.
Certified copy today.
And moreover, Milord, that
Yes.
pre-owned.
Whatever, now there's no point, right? You don't permit us to correct if the mistake, if any, you can, it will be ground in SLP. Yes.
By diesel lordship,
Ah,
I'm for the petitioners, my lord.
ah.
The petitioners have approached this honorable court aggrieved by the conditions imposed by the honorable DRT.
Two remedies, either file an application for modification or go to DRAT.
Lord, the going to DRAT is not an efficacious remedy, my lord.
Why?
The reason being, once conditions are
Right of appeal
No,
is a
Milord.
creature of statute, and supposing if it is impaired by the statute by imposing certain conditions of pre-deposit, the party is required to avail this. Mr. All of you people know, we have no reason to believe that you have not read three-judge bench of Supreme Court in Satyavati Tandon.
No, my lord. I'll explain this, my lord. The reason,
Explain
why it is not.
three-judge bench.
No.
Ah.
Why it is not.
Explain where is the judgment? How will you explain?
No.
Three-judge bench Satyavati Tandon, give it to him. He will explain.
No, my
Give
lord.
it, madam. Give the, no, not this. Judgment. Give this, not 14, madam. Give that.
No, not the judgment,
Give
my
it
lord.
back.
I will just explain why it is not an efficacious.
Satyavati Tandon, give judgment Satyavati Tandon 2010. This.
Because the reason is on imposing the
No.
conditions.
The sentence is, this is what you are required to explain. Although respondent borrowers initially approached the debt recovery tribunal by filing an application under section 17 of the SURFACE Act, the order of the tribunal indeed is applicable under section 18 of the Act, subject to compliance of the condition of pre-deposit, and without exhausting the remedy of appeal, borrowers have approached the High Court by filing writ petition under Article 226 of the Constitution of India. We deprecate such practice of entertaining writ petitions by the High Court in exercise of jurisdiction under Article 226 without exhausting the alternative remedy available under the law. The circuitous route appears to have been adopted to avoid the condition of pre-deposit contemplated under second proviso to this law under Article 141 binds us. And repeatedly we have been relegating every day almost.
True, my lord. I'm not in denial of this, what your lords.
Not denial, you can't deny. The Article 141 applies to us as well as to you also.
But here, my lord, what has happened is.
Are not efficacious. Nobody, the remedy is efficacious, right? Deposit, condition of pre-deposit, nobody
It
is.
is not about that, my lord. The reason is once condition is imposed, then the NCLT jurisdiction also comes into play, the jurisdiction of the IBC law.
All arguments you can
That
raise,
is the-
all arguments which you are raising here, you can urge before. The law does not prevent you from telling that since LCLT proceeding are this thing, therefore initiation of proceeding against me is bad and everything.
But
All you
it is a
can
feature of the statute, my lord. It cannot appreciate the fine nuances of the IBC law, my lord. Because the DRAT as well as the DRT, both are pieces of the same statute, my lord. They cannot decide on the matters relating to a different law and a different tribunal and a different.
No. There is no question of deciding anything.
My lord, the reason is.
Naturally, the DRAT cannot quash the proceeding pending before National Company Law Tribunal, right? It
So what
cannot.
is happening now, Milad, because of the imposition of the condition, it amounts to recovery of the dues of the corporate debtor by the DRT, Milad.
All we are telling
What
is, what is happening is this is happening with you. What we are telling you is that avail of remedy.
But then,
All this argument you can raise in appeal.
Milad, then what happens,
And
Milad?
supposing if in on this thing, Calcutta, you are not granted relief, we are open 24, 5 days a week.
Milad, because
We are
the
open.
proceedings before the NCLT are being prejudiced,
Come via Calcutta. That's what we are telling.
Milad, it may not be efficacious
Way to this court is via Calcutta.
because the judgment of the
We have read
Supreme
it,
Court.
Mr.
Yes, Milad, that is there. I will also like to just point out.
We will record your submission. It's not efficacious. Fine.
Milad, before that, Milad, I just request a lordship may kindly.
So this, Mr. We have been repeatedly passing an order. None of our orders have been reversed by Supreme Court. directing us to entertain a petition.
Kindly see.
And
page
we are
213.
bound by, Mr. Please appreciate, we're
Two
telling you,
months.
we cannot take a different view, even if you can continue till 4:30, no problem. Yes,
I'll just like to show this one small.
yes,
Page number 213, my lords. I may read, my lord, page number 213, paragraph number 35, my lords. Where the-
no, Mr. One thing, stop reading pages without telling the context. We don't get it, what 2:30.
my lord,
Then
the-
you will read 148, then 78, then 43,
no, my lord, the
then
con-
page number 2. So you should tell that I want to read so as to, in the context of this.
Yes, my lord.
In the book also, they don't directly start printing. There is a preface, right? So not the first page.
My lord, my purpose for reading that is, my lord, because the bank has
You
taken.
read, your performance is being watched by your clients. Therefore, you are reading. Read it. What can be done?
My lord, because the only
You
reason.
practice in Hyderabad only, right? You don't know what is the view of this court in this surfacey matters. Then
But why I have approached this is, my lord, because there's an interplay between IBC as well as the SURFACE, and the DRT, being a creature of SURFACE, cannot appreciate the nuances of IBC, my lord. That is the reason why I'm invoking the writ jurisdiction of the honorable court.
you can very well invoke the writ jurisdiction, fundamental right under Article 32. File a writ petition. It cannot interpret. Like, there's no question of interpretation, Mr. It's all misconceived. Yes.
It's a genuine issue, my lord, because once I pay here and all, then the proceedings, right now, the respondent number 3 company is under liquidation, my lord, and there is a COC which is constituted. Any deposit of this amount under this act will prejudice the COC, my lord. When under IBC overrides all other laws, my lord. IBC overrides all other laws. But still
Why
the-
did you give guarantee to the transaction? You should not have given. So all
They
this
are the
problem
directors,
would
my
have.
lord.
Give.
They are the
This
directors.
is Satyavati Tandon you wanted to explain. Please explain what Supreme Court says.
Well, I can only say that this relates only to SURFACE and not the interplay between IBC insolvency, bankruptcy, and SURFACE. When I'm exclusively coming under SURFACE, if my issue was only related to SURFACE, complaining about the actions of the respondent bank in relation to any procedure or any kind of this, actions taken under SURFACE, then I would say that this judgment will be applicable to me, my lord. But my issue is entirely about the preliminary issue of jurisdiction, my lord. I am saying the actions taken by the bank are void ab initio in lieu of the proceedings initiated against the principal borrower before the NCLT under CIRP proceedings way back in 2019, my lords. It is not that initially itself they have instituted proceedings. Way back in 2019, they have instituted proceedings before the IBC, before the Honorable NCLT. NCLT has passed a CIRP order also granting moratorium, and within next month they have instituted proceedings under SURFACE, my lord. And the order of the CIRP, my lord, it clearly says SURFACE proceedings are barred.
What is the extent of loan?
86 crores, my lord. I'm not denying, my lord, and I'm not saying that I'm not responsible also.
Better pay
What I'm
instead of
saying is-
arguing all this.
DRT is not the forum, my lords. When the matter is already seized,
The forum does not exist anywhere in the world. You should be allowed to live in peace after this thing. That is the argument.
I mean,
Yes.
the NCLT seized
There
of
is
the
no
matter.
forum.
NCLT seized of the matter.
So they should, NCLT, this they will never be decided. So no proceeding against you can ever be initiated.
Lord.
This is the argument.
The proceedings is against the corporate debtor, even against the corporate personal guarantors to the corporate debtor, that is myself, the petitioners herein. The ministry has issued a notification, my lord, enabling the provisions under IBC. So they can proceed against me under IBC, my lord, and they have in fact initiated proceedings. That I request the lordship may kindly see Form B notice which they have issued, my lord, against me, which is at page number 53, my lord. In that, all the properties which have been recovered are present in that, my lord. I request your lordship may kindly see page 53, my lords. Page 53. This is Form B notice, my lord, issued under Rule 7 of Insolvency and Bankruptcy, application to adjudicating authority for insolvency resolution process of personal guarantors to corporate debtor. I am one of the petitioner herein. I am one of the persons here, my lord, and my property which has been auctioned under SURFACE reflects. Your lordship may kindly come to page number 59. It reflects as item number 19, my lords, page number 59. Page number 59, my lords, item number 19, and then 20 and 23, my lord. These three properties which are reflecting under the proceedings of IBC to be instituted against me, that is the personal guarantor, they have proceeded under surface, my lord. It is not that they do not have any right under IBC to proceed, my lord. There is a section 95 application is there. The remedy is available under IBC under section 95 to recover against the personal guarantors to the corporate debtor. And the Honorable Supreme Court in the case of Lalit Kumar Jain also categorically held, my lord, that personal guarantors being the close helm of the in charge of the helm of the company.
Not 86 crores.
So it is not the case that, my lord, there is no remedy for the bank, my lord. They should recover gone under the
No,
IBC.
we are talking about your remedy, not about bank's remedy.
My lord,
Your remedy.
because there is interplay of two different
this-
statutes, my lord.
You understand, right? Three-judge decision, three-judge bench binds us of Supreme Court and this.
My only
Fine.
small suggestion is, my lord,
I
It is
think
only under
we have
subject-
given you enough time.
it is only under surface, my lord, not, it is not considered IBC, my lord.
So file under section 18, file an appeal, argue. Nobody prevents you from arguing all these points in Calcutta.
My lord, otherwise, if your lordship is not inclined under this aspect, my lord, another small request which I would like to make is the order which has been passed, my lord, the conditional order. I have my financer has deposited a amount in the bank, my lord, with the respondent bank. At least that may be considered as my compliance, my lord.
No, we don't. You file an application before DRT. Seeking all this modification, anything would have been filed before DRT.
No, my lord, because it has given a
Fine.
clarificatory
No,
order.
we are not here to suggest you the remedy, right? We are deciding this, right? Mark the presence heard on the question of admission. The petitioner, who is a guarantor to the transaction in question, has assailed the validity of the order dated 14/7/20.
May I please you. But maybe I would like to circulate this judgment copy, my lord, which my lords have rendered in the first round of litigation on the same subject, the same.
What? They're not required to pay anything, right? So,
Certain given.
the
That
Basic
observation
Pollution
should be-
Control Board should give you money. What is the judgment?
My lord, the concept of this environmental compensation has come into.
We are issuing notice, right? We are issuing notice.
I have questioned one notice before my lords.
So
Saying
what,
that,
I mean, you want today the appeal should be, petition should be allowed. What do you want? This is listed for admission. We have told you that we are issuing notice.
Very-
You still want to argue?
No.
So then argue that we will decide it.
my lords may order notice.
It always, different view can always be taken.
Yes.
Don't worry. Yes. Argue. Yes. Yes, argue. Please go ahead.
My lords have made some observations in the judgment, saying that the basic fact that I am not a party before the NGT has to be taken into consideration. And that I have complied with all the conditions and subsequently CFO was granted to me. That also is to be taken into consideration. These two observations my lords have made, my lord, which they have not taken cognizance of while passing up the impugned order.
So, I mean, without your argument, court cannot issue notice, right? That is the objection.
I am not objecting to anything. My lords may order notice.
Then why are you arguing that? We said that we are issuing notice.
Very well.
Heard on the question of admission, notice.
With your lordship's permission, my lord, one preliminary submission in this matter, the writ has been filed challenging two different proceedings under which under two
Take
different
an
laws.
objection, notice,
Okay.
issue notice on behalf of respondent 2 and 3 is accepted by Mr. So and so who prays.
Right.
May I please the lordships? It's a matter, my lord, lordship's order at page 94 to 97, my lord. The petitioners are working in the society.
Now, yes, we want to put an end to all this. This is one order you have got and then every petition you are filing. Mr. This order of allotment was passed on 26/9/2022. You first tell us what you were doing for 1 year.
Initially, stay was granted, my lord. Lordship may kindly consider the stay order I have appended, my lord. This is
No,
at
no, no.
page 77. Once stay granted, my lord, they ought not to have been proceeded further matter. The entire proceedings have been-
You are challenging the order of allotment, correct?
Yes, yes,
It was passed in September 2022.
yes.
We are in the month of
October 2020.
1 year, 10 months, 1 year, 1 month. What you have been doing. This is in the context of interim relief. We will not grant interim.
I'm requesting the lordships kindly allow me to persuade the lordships kind consideration.
Yes.
This is the
You
order.
tell us, you explain why, what were you doing from 26/9? What did you do?
Page 77, if lordship so
So
please.
you tell, Mr. Not
There is
this.
stay.
Forget about it. Page 77, 110,
Very well.
55, 54. You are not here to tell us the pages, right?
Once this under initial.
Tell us what did you do from 26/9/2022?
This honorable court granted stay, my lord, they ought not to.
Where is stay? In this petition.
In the same, the entire proceedings have been stayed by this honorable court. They ought not to have proceed further.
Oh, which petition? We stay granted where? Which case?
This is three.
Which petition or anything? Were you a party to that petition? What?
This is page, that's why I'm.
You
referring to-
are, no, you have not read it, Mr. You
I
get
make
ready.
one submission, I leave it to lordship's kind decision, my lord. This is the matter, the impugned proceedings in that writ petition as well as in the present writ petition is one and the same. The entire memo has.
No, why you are not telling the correct facts?
Facts,
You have filed the petition in which stay was granted.
the persons who are working at par with the petitioners have filed the.
You are not party.
I'm not the party because once stay
then-
granted, my lord, my submission, once stay granted, the respondent ought not to have been offered the same.
No,
But
no.
They are implementing for this, them. They are not.
No, no, this, you are not G. Narasimha Reddy, right?
This is-
And you are not
Narasimha-
J. Ramakrishna.
Dear Ramakrishna, in respect of model school is concerned, there is a first case of the societies were not under brought to the purview of the presidential order. Then page 77, Miller, 39866 of
No, no,
2020.
please explain, Mr. What were you doing from 12/9/2022?
Once stay granted, Miller, entire
So you
proceedings.
were waiting.
No, my
You were
submission, Miller, it is not restricted to
Stay
petition.
granted in somebody else's case.
Entire,
So you were waiting that.
Entire proceeding
then why-
has been-
So supposing the entire proceeding has been stayed and they could not have done, file a contempt against them. Why file a petition?
because I am
Simple.
not the party in that
That-
petition. In that
That is
petition, not the party.
that is the thing.
The persons individual who have obtained the stay, they cannot file.
No, you are arguing that a whole thing was stayed.
I'll read to the lordship's kind consideration the order minute and then I'll leave it to lordship's decision.
No,
Page
no,
18.
you understand what is it? That we are not inclined to grant interim relief because you have come to this court after 1 year, for which there is no explanation.
Sir.
We are entertaining the petition, but we will not grant an interim order, and even in these matters, if there is a delay, we will vacate the order.
I'm sorry, my lord. That delay is concerned, if lordships have allow me to make one submission.
Please make, Not only 10 submissions,
Answer.
but answer relevant question.
Relevant question is time.
Mr.
The 1 year,
Please,
10.
This council, please understand we put questions so that the issue is, I mean, on relevant issues, right? You can argue anything that his name is so and so, he was born in the year 1975, you can argue.
What?
We will
14
hear.
months delay, Lord.
The idea is not to prevent you from arguing because we sit here to hear you. Right?
14 months delay, lordships have taken, my lord, my submission to that extent, this court pleased to suspend, this honorable.
No, we have committed a mistake. We are telling you.
I'm sorry.
In that case also, which case 14 years delay, we have condoned.
No,
Which
lordship,
case?
no. There is a Katina.
Which case?
My lord,
Which case?
almost
We will
12
make
cases.
it. Please give the list. Sorry,
Yes,
it's a wrong order. Wrong order passed
May-
by
may
us
one request?
because we relied on you.
Lordship, so please, this matter may be tagged along with the writ petition, my lord, because
Which writ petition?
this is 36, the initial writ petition, 39866 of 2020.
39.
866 of 2022, which is filed immediately.
You are not filed. You are not filed. That's what we are telling you.
That is because my humble lordship may kindly consider once stay granted, other side, my lord, they would not have been operated. They are implementing for them and taking steps to organize the things, my lord. That's why I am before the lordships. If lordships kind consider, my lord, extend the same order which is granted
No,
status for
not after
1
1 year, 1 month.
if lordship so please tag along with that main case, my lord, I'll go by that.
Learned counsel for the petitioner after arguing the matter to some extent.
One more request, Minute. Petition number 9 and 10 is concerned. The typographical mistake was correct. Instead of minority, it was typed as social welfare. I may permitted to correct the same.
You will have to file an application, right? Please file.
But I'm sorry, Miller, I'm sorry, troubling the lordships.
No,
Either
not troubling. We are asking you relevant questions.
14 months is
It's
concerned,
not-
Miller.
No, there is a delay, right? You have to explain that delay. Yes, in seeking an interim relief, we are entertaining your petition, issuing notice, but we are not agreeing to granting ex parte interim order after 1 year and 1 month. That's the problem. Yes.
But I have explained, I'm sorry,
Yes, a memo.
I'm obliged.
A memo has been filed seeking leave of this court to withdraw the writ petition. The memo is taken on record in the result rate. Memo has been filed seeking leave of the court to nine. None for the petitioner. None had appeared.
Lord, my friend filed a counter. Lord, it requires not filing up to reply. In addition to it, Lord, Mr. Mohan Reddy was appeared not on behalf of the petitioner, where his personal inconvenience is there, not he's seeking some time, not subject to it.
Yes. What happened to arbitral tribunal has been constituted?
The lordship,
The 9%, not the applicant.
No, we are asking you, arbitral tribunal. We know that it is against an order under section 9. Not that we are saying that it's something else. We do this basic homework, Mr.
lordship, may I explain, lordship?
What is section 17 of the Arbitration Conciliation Act?
Lord, where the,
What is section 17?
Lord, the arbitration, not,
Huh?
I'm sorry, Lord, I myself.
What is section 17 of Arbitration Tribunal Act? You are telling us that this is section 9. So we are asking you what is section 17?
bid protection.
Huh? Give arbitration conciliation. Section 17.
Yes. Interim measures ordered by the
Yeah.
interim measures ordered by arbitration.
So section 9 operates till parties are able to approach the arbitrator. This order was passed on 2/8. This thing, when this order was passed under section 9.
Not 29/4, 22.
Then one and a half year has passed. Therefore, we asked whether arbitral tribunal has been appointed. You are saying that this is section 9.
Last
Is this the answer?
Sorry.
Last May answer.
No, Mr. Arbitral Tribunal has been constituted or not constituted. Simple thing, if you don't know, say you don't know.
Arbitration, Lordship. There is a background in this. Lordship, we have approached the arbitral tribunal.
You take time, he also doesn't understand.
Lordship,
Learn it counsel for, you want time to what, do what?
Reply, not
tribunal award has
There is nothing.
Lordship, award is not. Against the award, they have withdrawn some counter claims. Again, they are invoking the same counter claim, saying we had withdrawn the counter claims before the award, arbitral tribunal. We have still had the right to recover these amounts. This is what we both parties refer to claims and counter claims to the tribunal. Comprised by
So under petition under 34 filed against award
against award, 34 is pending for
pending. So then
Then again, once a matter has been adjudicated, now they are trying to recover my monies, which are
Yes, sir.
counter claims rejected.
now we have understood. What he wants to say that the award, the arbitrator was already appointed, he passed an award, and thereafter that award is under challenge at your instance under section 34, right?
Yes.
So if they are trying to recover any amount instead of this thing, you should have approached the court under section 34 by seeking appropriate measure. What is this?
I just said I
Huh?
But I am instructed not, it's 10 minutes, not the thing. Last second was approved by this. But some time may be, not so much.
Learn it counsel for. Mister, you prepare a synopsis. Prepare a date-wise synopsis.
As a matter of fact,
Instead of telling that it's a history, it should be 2-page synopsis. The idea is to save time, not to give a speech on what is the history, what is the geography, right? The time of this court is precious, that you are under an obligation to save it by effectively assisting. Give a date, what happened when, 2-page synopsis. And submission, 1, 2, 3, 4, that's all. 11.
Where to appear for the petitioner?
Why? It's my colleague. Let this petition be listed before a bench in which one of us write his lordship.
This petition is filed, my lord, challenging the order of the Human Rights Commission, my lord, order passed by the secretary in the absence of commission, my lord.
My lord, so you ought to page 30, my lords.
Page?
I thought in writ petition number 14326 of 2005, my lords. Page 30, my lords. I may be permitted to read operative portion of the order, my lords.
What is the order?
Last para, my lords. In the circumstances having regard to the admitted fact that second petitioner Shivakumar Chari was illegally detained for a period of 5 days, and having regard to the fact that there is no specific information regarding the injuries of the nature of injuries suffered by the said Shivakumar Chari, we deem it appropriate that the said Shivakumar Chari be paid public law damages for an amount of rupees 10,000 within a period of 2 weeks from the date of receipt of the copy of this order. It goes without saying that the direction given today does not derogate the rights of the said Shivakumar Chari to take up appropriate proceedings against the second respondent, either civil or criminal matters. Instead of availing remedy before civil and criminal courts matters, they have filed a complaint before the HRC seeking compensation matters, which HRC does not have power to grant compensation matters. As per section 18 matters, Lordship, please.
Let him argue. He didn't say he's the petitioner, right? Please wait, madam. Let him.
Lord,
Yeah.
the,
You want to file any counter? No. No. All. Yes.
Lord,
What is
as per section 12, my lord, the complaint is filed before HRC, my lord, on the direction given by this honorable court in
where is the direction?
Lord, in WP number 4143.
No, where is
Page
the
number
order?
28.
That is
28.
appropriate, directing the petitioners to approach the appropriate forum to
No,
seek
no,
remedy.
this is not appropriate.
30, my lord, 30, page 30. He was illegally detained, my lord. The victim was illegally detained in the police station for 5 days. It was established prima facie, and this honorable court gave the finding to that effect and directed the part.
Civil or criminal?
Yes, my lord.
That is not a civil or criminal means damages. Miss.
Yes, my lord.
Suit for damages.
But the Human Rights Commission is having power under section 18, my lord, to award damages, my lord, compensation, my lord, for the act done by the state. State, my lord.
This is the problem, right? You invoke the jurisdiction of under Article 226, got 10,000 rupees. Right?
It was sumo, it was sumo
This
taken by
is-
the honorable court, my
So
lord.
this, under this thing, only an amount of compensation for infraction of fundamental rights can be guaranteed, right? Can be granted under Article 226. Now, this is what,
But in the absence of commission, my lord,
no,
the
we don't
secretary,
think that commission is the appropriate forum. And in any case, you should seek clarification of this order, civil or criminal. So it says civil or you seek clarification, then probably you could have filed. This is not a civil or criminal proceeding.
it says civil before the Human Rights Commission, my lord, it's
And
appropriate.
criminal with, magistrate.
But criminal, that is a criminal prosecution, my lord, that is separate. But under section 18 of the Human Rights Act, my lord, we make payment of compensation or damages to the complainant or to the victim or the family
This-
members,
this
my lord.
is Civil or criminal.
Even the order, the order,
We will grant you the liberty to file a civil
my
suit.
lord, in this case, my lord,
All right.
in the absence of commission, the registrar, the secretary closed the proceedings, my lord. This is not the commission passed the order, my lord.
Huh?
Under section,
Commission did not pass an order.
yes, my lord. Secretary is not the competent to dispose the complaints by the, of the commission, my lord. Page 23, my lord.
No, where is the ground taken? So we will ask the commission to pass an order afresh if that is the ground.
Lord, remand the matter.
Which is, no, remand means what is, where is the ground taken that commission did not pass an order? Where-
Lord, I will.
It's a paragraph number 12 of the writ affidavit.
The
What
Well,
para 12 is nothing
Secretary
brief
of the
facts.
Human Rights Commission had
In
no
page
power to-
number 18, 18 of the said writ affidavit.
Grounds,
They have
my lord.
taken a plea that the secretary is not having powers to pass an order.
Ah,
If your lordship so pleases, paragraph.
file an affidavit, madam. Learned counsel for the petitioner while inviting.
As per your lordship's directions, my lord, a compliance report has been filed by the pollution control board, my lord.
I filed a report.
I would like to file objections to the report, my lord.
Learned counsel for the petitioners. There is no discharge, nothing. So you. Yes. Yes, this public interest litigation. This public interest litigation was registered. No person belonging to Christianity is a head of the temple, right? We have recorded this, Mr. Your statement.
Yes.
Ma'am, please. My lord, they're asking only 4 weeks. I don't know why, my lord. They should have, I thought they will be asking.
They should have ideally speaking new year.
Application itself, my lord, so underlined, my lord, why they are taking action.
Last week of December, Mr. Harinder Prasad, Lieutenant Counsel for Respondents, once again praised for adjournment. List in.
After the respondent tab,
Sorry.
I filed my count. The facts are like this, my lord. The respondent is in the position, my lord, since 1985. He has been given the land on the lease, my lord, 111 square yards. And the lease amount was paid, my lord, till 2022 also he was paying it, my lord. And it was only in the month of the May, my lord, where
What the action has to be taken by them, respondent number 7.
Yeah, file a counter. There is a status quo order, my lord, in respect of this respond number 10, my lord.
Yes, madam,
I am appearing for respondent number 10.
that is correct. Do you have any idea what is the last order sheet?
Yes, my lord.
Don't know.
We have filed a counter, my lordship. In this, they have issued a show cause notice, my lord.
You had said this, that you will take steps for removal of encroachment. What have you done since
We have
16?
issued a show cause notice, my lordship, following the
Show cause notice and giving them time to approach the court and seek stay, right? You advise them that please go to the court, seek stay. We don't want to proceed against you. What to do? Court is after us. So please go to the court, seek stay. We are issuing notice. We will not demolish. We will not remove unauthorized construction and encroachment. So they have gone there and court and sought stay.
We have, the report will file the report.
Arey, Mr. You tell the last date of hearing, the counsel, somebody else had appeared, Mr. M. Ram Mohan Reddy. You are there. You are. No. So Mr. M. Ram Mohan Reddy had 1 minute, had told us that they had initiated an action for removal of encroachment, and this respondent number 10 and his family members threatened of self-immolation. So therefore, this they did not take, but we will take action for removal of encroachment. This is the statement. So we are asking what has been done. She says, we have filed counter and notice issued. Issuance of notice does not amount to removal of encroachment. No, that is fine, Mr.
I am for the
1 minute.
respondent.
Few words.
Few words. This is the order sheet. You read and then say. Why few? So many words. Whatever you want to say. There is no problem. But the predicament is that they do not know the order sheet also. He is not there, and she doesn't know what has transpired. So she is unable to tell anything. Right? So naturally our query is what action has been taken.
My lord, in this case,
You explain to her.
yes. My lord, I also received the instructions, my lord. That's what I want to place before this honorable court, my lord. In this case, my lord, the small extent of the lands is allotted to 104 individual plot owners, my lord, for establishing shops. And all those persons established temporary sheds during the period of 1980s. From that day onwards, they are continuing in their position. Recently, my lord, due to the heavy rains, my lord, one of the tree fell down on these temporary structures. Immediately, he made the he completed the tin shed, my lord, in that same place, my lord. Now they are terming it as a illegal construction and they are terming it as a encroachment. But my lord, later on, my lord, once we noticed about all the issues, my lord, the inquiry, my lord, they stated that this is a allotment is made during the period of Gram Panchayat. And this person is also well, the person filed the writ petition before this honorable court, my lord. He was a Sarpanch and he is know about all these things. And he made the complaint saying that no action is taken on that. And in this case, my lord, we immediately made an attempt and issued the notice. To that effect, my lord, he replied saying that this is not the illegal encroachment. This allotment is made by the Vedam Gram Panchayat for establishing the shops. That is the reason, my lord, now, my lord, what the steps we are initiating, my lord, that will be completed and we will file the detailed report before this honorable court, my lord.
16-8 time was given. Left 2 months.
It is true, my lord. It is true, my lord. There is some delay because they forwarded the instructions to me, my lord. I also sent the draft counter to them.
No, not draft counter. You have to take steps for removal of encroachment, Mr.
My lord. Just now I brought to the notice of this honorable. It is not the illegal encroachment, my lord. This is allotment made during that.
Why did you make this thing, Mr.?
My lord, by that time, my lord, they are not aware of all these things. My lord, immediately issued the notices. That is happened.
No, we will file the detailed
We
report.
should record your presence now,
Yes, madam.
I am
your
for the,
presence.
Yes, madam. I am appearing for the government, my lord, the municipal administration.
Or write his
I am
name.
for the respondent.
Learned counsel for the petitioner. Learned counsel for.
Alert, the correspondent will file a detailed report, alert. How many hospitals are there in Lund and how many beds are, how many?
No, you have filed the affidavit of counter affidavit. Amount of budget allocated for extending
Yes,
medical facilities.
yes. I filed that, but on
Where is, when have you filed?
12/9/2023.
12/9.
Respondent number 1.
Hmm. What is the amount?
Pardon.
What is the amount of budget?
Yes, there in page 9 of the counter. 19, page 9. The year 1920 minutes, 5,783.91 crores. But the year 23-24 minutes, 12,364.
And the in response to the order dated 16. Yesterday I had given dictation in item 19 to somebody. Yesterday I had given dictation in item number 19 to somebody. Whether she has typed it, whatever. Some. Yesterday it was there, no 19 finally. Yeah. 18, 18. Yes, Mr.
Please, yeah.
Petition is filed seeking your fixation of early date for hearing.
Completed. Yes,
May I please, you. I'm appearing for the petitioner.
yes.
I have moved an application for early hearing because the counseling is going to be end up by this month. That is the reason I moved an application to heard the matter as early as possible.
When Mr. Now,
The 20th is the last date, madam.
20
30th of this month. All rounds of counseling including
will be
mop-up
over.
and stay vacancy also will have completed.
So what is, you can argue today also if you are ready.
Yes, I'm ready, my lord.
Ready?
Yes.
Ah.
Lordship, this writ is filed for seeking the direction to direct the respondent number 2 and 3 to consider the application made by the petitioner herein, my lordship. He has made 3 different representation before the respondent number 2 and 3 to consider his
Oh,
application.
you
as
ask
local.
your colleague to open the flap like this, he has tied it like this, a design. Why? It's not supposed to be done. Yes.
Yeah.
Ah.
This the petitioner has made 3 different representation before R2 and R3, and they have given a reply
No, the prayer is to
to consider the
treat
petitioner
them as local.
to consider the petitioner for the admission into PG medical course under NEET PG 2023 in TS under local category to suspend clause 4 of the GPO number 646 of 1979, treating the petitioner as local candidate. As far as concerned, the petitioner has pursued his last 4.5 degrees from neighboring state from Karnataka, wherein he belongs to a Telangana state by birth, and he has completed 10+2 from Telangana and Hyderabad. He is forced to move to the Karnataka state to pursue his graduation, MBBS. Later on, he has
Where have you done?
Karnataka state.
Which place? Karnataka.
Devaraj University.
Devaraj University.
Huh?
Devaraj University, my lordship.
Huh.
Sri Devaraja URS Medical College, Kolar, Karnataka. And he has appeared in NEET 2023. He has scored 385. And
What is the definition of local candidate?
local candidate by birth, he belongs to a Telangana state and domicile of Telangana. He is the domicile of Telangana, my lordship. In their prospectus, they have clearly stated that lordship, kindly have page number 72, my lordship.
We'll hear you on Monday.
Please, my
Get
lordship,
ready.
there is an urgency.
Monday. Oh. So he says 28/10, no? 20th October. Before that, we are hearing on 16/10. Get
Okay.
ready. Prepare a synopsis where he has studied. How is it as a local candidate? What does local rule provide?
Yes,
You are not a local candidate.
he is a local.
You are saying what, Mr. You should be a local candidate as per the rule.
Yes.
Heard on IA 1-2 of 2023.
He made this yesterday's matter, Lordship, where your Lordship, while dictating and notice that in my appeal before the tribunal came to a conclusion that the arbitrator had no jurisdiction under section 61 of the
So
Act. So, Lordship, the humble submission, Lordship, is the tribunal is a creature of a statute, and section 76 of the Act, which defines the powers of the tribunal. Lordship, I am permitted to read the section 76 of the Act. where an appeal would lie against an what passed by the
76 of
arbitrator.
what act?
Cooperative Societies Act 1964. Your Lordship, Section 76, Your Lordship, is the provision which deals with appeals to the cooperative tribunal. While yesterday, Your Lordship had seen Section 61 is the main section which dealt with the scope of the arbitrator, whether the Your Lordship, transactions touching the business of a society could be referred to a
What is the
arbitrator.
point, Mr.
It's a
You just
76
like
point.
continue the suspense till like the
Yeah.
76, 86, 96.
Since upon 76 up
126.
clause 4, Your Lordship.
Arey, Mr. What is the point? You must
Right,
first
Lordship.
tell this the submission I want to make,
Lordship.
then say 76, 86,
The
115,
submission I'm making, Lordship.
120.
Under section 76 subclause 4, the jurisdiction of the tribunal is restricted to the subject matter of the appeal. Your Lordship, in this case, Your Lordship, because the words used therein, Your Lordship, are that in disposing of an appeal under this subsection, the tribunal may, after giving parties an opportunity, pass such order thereon as it may deem fit. In my humble submission, Lordship, the words pass such order thereon would limit the power of the tribunal, Your Lordship,
Any
to the
case law.
Yes, Your Lordship. In fact, while the
No, you should thank us. We told you. You had considered that appeal deserves to be dismissed.
I got it, Lordship, but the case law which Lordship I have is under the Income Tax Act, not under this act. But the principle, Lordship,
So, therefore it will not apply, right?
but the reasoning of the,
What is, Mr.
the reasoning I am permitted to title.
Hmm?
Am I permitted to read from para 35 onwards, Lord. There were two issues that were raised before the Honorable Division Bench. The second issue, Lordship, was the one concerning the scope of the tribunal, appellate tribunal's powers. Para 35, if I may permitted to read it. Para 35, Lordship. Para 35, in the present case is governed by the Act of 1922. We have to consider section 33 of the said Act. The language of section 33 subclause 4. The language of section 33 subclause 4 clearly indicates that the appellate tribunal may or can pass orders thereon on appeal as it thinks fit. Your Lordship, the wordings are similar, Lordship. The tribunal may or can pass orders thereon on appeal as it thinks fit. Although the powers of tribunal are thus expressed in very wide language, the word thereon restricts the use of such wide powers of the tribunal to the subject matter of the appeal. What plainly follows is that the tribunal's powers are limited to passing such orders as it thinks fit on the appeal. In other words, the powers of the tribunal are limited to the subject matter of the appeal. Then, Your Lordship, next paragraph, para 36 and 38 also, Lordship, further elaborate the same point. While, Your Lordship, the Act has thus left the parties going up as
Where is
appellate.
the appeal provision in this case?
With sincere apologies, Your Lordship, it's not extracted. But
It has been reproduced. 33(4).
with sincere apologies, Your Lordship. it's
You
not-
don't get the Income Tax Act 1922, you can't get.
Yeah.
So what sincere apology?
I'll try to trace that. Your Lordship, but the word used, Your Lordship,
You
thereon.
want to know whether it's in perimeteria with the provision. Simple. What, Mr. Half-hearted attempts? That too on being told, right? This is your performance on being told. First thing you should have struck you is that this thing 76(4) is this, 33(4) reads like this.
Yes,
So therefore perimeteria provision, and that's why parathad. Income Tax Act 1922. Court has to find out, right?
Apologies, Your Lordship.
What, I mean, this is, it's not that we are taken by surprise. This is the after preparation, this is your performance. And this, yes, Mr. What do you say?
Yes.
The matter then has to be remitted prima facie subject to what you say.
Yes.
Has to be remitted because see,
Make a legal proposition, nothing
yes, yes.
Not my first legal proposition.
No, the what legal, because you were not there yesterday, so you don't know the legal proposition.
I was there online. I was there. I was present.
So we were dictating the order, then also you didn't say anything. Yesterday, during dictation of facts, we realized that this position, then it has been adjourned. So Mr.
So, therefore, my lord, I will.
No, that's correct. But see, you understand his submission. What is the submission?
My lord, the only thing that he said that the order of the CQ has gone beyond
22.
because there was a limited challenge.
No, 1922, madam. 20.
My lord, what my friend argued was that there was a limited challenge.
Ah.
Issue there was not.
So therefore, the tribunal ought to have was only supposed to examine whether 8% interest should be granted or not granted.
Yes, my lord. Now, the only submission
So
that
now the whole order in his appeal has been set aside. How can you, I mean, this what he has contended with para 35. What do you say?
submission, my lord, I'm not going getting into. My lord, may only consider this point. My lord, any order passed without jurisdiction is nullity. My lord, this is my first proposition. My lord, the second proposition, my lord, that today the order which is there before my lords is an order under Article 226 session, which is the supervisory jurisdiction of this honorable. My lord, the impugned order which is there before my lord is under Article 226, where a supervisory jurisdiction has been exercised by this honorable court, by of course learned single judge, right? And then he has said that the order is without jurisdiction. My lord, then my lord, the third thing is whether the parties can confer jurisdiction to a court which doesn't have jurisdiction.
No, that is not the point. Nobody is saying that he can confer jurisdiction.
My lord, therefore, the fundamental point is, my lord, doctrine of merger. Today, my lord, the order of the arbitrator, appellate tribunal.
Everyone, that's why we asked you, Mr.
Yes.
Have you understood the submission?
Yes, yes.
What is the submission?
My lord, submission was that the challenge was limited to an extent of interest. So whether the appellate tribunal could have overturned the entire, my lord, that's.
It could not have.
My lord, I point out, my lord, the
Revision bench decision of para 35 of revision.
the provision of law under which the appeal was preferred, my lords.
It was preferred under section, this thing's,
My lord, just read out, my lord.
76. 6.
7, 6. My lord, we come to 2. What is that the court can check? The legality and propriety of the order under 76(2). My lord, so the question of law is whether the power of the appellate court can be restricted or narrowed down to an extent which makes section 76(2) OTOs.
You don't understand the challenge, Mr.
My lord, I have.
Yes. He had challenged the order. Who is narrowing down the scope? He has preferred an appeal.
Yes.
Only to the extent of grant of interest at the rate of 8%.
Yes.
So, what was the question before this thing? Appellate tribunal. The appellate tribunal could have examined the legality, propriety of any decision, any order under section 76 of grant of interest only. Rest was accepted by him.
My lord, that's according to my humble and
Fine. That's what you can argue. But you understand, right?
interpretation.
Fine.
And my lord, supervisory jurisdiction, my lord, that's also my contention before my lords. That under 226, when this honorable court exercises power under 226, such will, my lord, it can always check the jurisdictional errors committed by the previous courts and the doctrine of merger. So today,
No, the court has not corrected any jurisdictional error. Court has upheld the order.
the court has said that the court has no jurisdiction. The arbitrator has no jurisdiction. Not that's a fine. My lord, I've got only limited point.
Yes.
I leave it to my lords.
Of course, you will have to leave it.
Yes, ma'am. So I have to bow down.
Article 136.
I have to bow.
Yes. Right. All right. Madam, you will not get it. I knew 1922, he is also not getting it. This is Mr. Oh. Yes, Mr. This continuation. Para 7. It's there, right? It has been typed by someone. You get it and para 7 onwards. Learn it. She wants to come. There? Yes, madam. Learned counsel for the appellant has invited the attention of this court You write the whole. Grant of interest are kept open, that it should not be granted. This is the order which we passed. Yes. One.
Obliged. One LR petition is there, madam.
Huh?
One LR petition is there, madam. Legal.
Allowed. LR. You are LR. Appellant's LR. Then allowed.
Two ID.
Allowed. Yes.
And then not only short question is involved in this case. Page number. An award was passed under section 28A of the Land Acquisition Act, madam. And the appellant received the compensation. And then they submitted a representation application on under section 28A3, asking to refer to the civil court. The LAO said that we have not received the amount under protest. The land single judge also at page number 9 said that we have accepted the payment without any protest.
Then what to do?
My submission is that, my lord, I may rely on one judgment of honorable single judge of the honorable High Court in this regard. I may submitted to move it is a single judge judgment, and also one Supreme Court judgment is also there, but it is
Now what happens to subsection 3 then? Language, express language. Any person who has not accepted the award under subsection 2.
he has to file a representation, my lord. I have filed a representation.
No.
At page number 8, my lord.
When did you receive? When was the award passed? Award was passed on 23/4/1986. And when have they received the compensation? When have you received the compensation?
$18,499 award, my lord.
23/4/1986. So when have you received the compensation?
Compensation received, my lord. 17/5/99.
17/5/99.
1999. Yes.
It can't be. Because you filed under on 24/4/93.
17.5 is an application you made.
26, from 26, my lord, from page number 26. From page number 26, we filed
Right.
representation.
So date is not known, right? When you received the compensation.
But the legal notice is issued by advocate. He said that
Received on 13/5/1999.
13/5/99. And thereafter they filed when? 99?
This is a contract filed by the SP.
No. But how can then he has then subsequently he has filed? Previously he had filed a reference. Then
This is subsequent to the OPE with the process. He received.
see how reading here. What?
page number 22, legal notice, I stated that on 17/5/99, we received the compensation. In the same month, I filed a representation. And that is not a dispute.
You have not even filed a reply. You say you have not received the payment.
No, my submission is that there is no dispute that we received the compensation and we submitted, we made a representation within time. That is no dispute. Dispute is that.
We are only, dispute is only that we are asking you the date when did you receive?
Yeah.
Because we have to state the facts in the petition
Yes.
while deciding the appeal.
Page 22, a legal notice was issued by my client and.
Date. If you don't, I mean, don't know.
Date
Fine.
mentioned 17/5.
We will say that admittedly you have received compensation before making an application under 2883.
17/5, legal notice, we mentioned the date 17/5/99.
Now, what is wrong with the learned single judge?
Only then single judge is not disputing about the making a representation. The point is that, my lord, at page number
The
9.
point is that you don't know the date on which you receive compensation. Point is, you don't know when you made an application under 28.3.
18/4/99 supplementary award passed and 17/5/99 we have received the compensation according to my legal notice dated.
When did you file an application?
Application filed in the month
Under
of
28.3 seeking reference.
May 2009, May 99 at page number 26, my lord.
May
17/5, page 26.
On that the day you received compensation, that very day you made an application.
On the day itself, I made a representation. The question is that we have not received.
He's saying 17.5. 13.5 you have received compensation, Mr. Not
Page 49, the counter. Madam, you must say when you have paid the compensation.
Yeah, 28A award was paid past 18/4/99. And they have received the compensation and they have filed an 28A3 application on 17/5/99. It's well within time. The only consideration, non-consideration of the application was that while receiving, they have not given under protest. They have received with satisfaction. Only a paragraph,
When?
not on the ground.
13.5.
When?
On 17/5/99, they made an application.
Compensation received and when date? Subsequently, when they received the compensation, you say they have received towards full and final set. Please give the date, exact date. Because in your counter, you are saying as 13.5. Subsequently, they might have received
13.5.
35.99.
13.5. He doesn't know. 13.5. Huh? So 13.5 there.
Yes. This is the counter filed by you. Please see page 47. In 49, you state in the para, last two lines of the first para.
It stated that they have received compensation, but the exact date is not there.
No, madam, see the.
Compensation amount on 13/5/99.
Yes.
Page 49, above the paragraph 4, last line, not on 13/5/99.
So then,
On 17/5/99, they made an application.
then why she is not telling 13.5?
We have to devote it.
Tell her
Sir,
13.
you have already received.
Yes, there is no dispute that minute.
Please wait. Subsequent to filing of counter, you have not filed any reply. The learned judge has already made even observation in the order. Please see. Though averment is made in counter affidavit, no reply is filed denying the same. What remains?
Yes, Miller, kindly see page number 9. Internal.
I think you better forget about it.
Yes, my submission, my only submission is that.
Yes.
The last lines of the judgment of the land single judge. In this case, an award by the respondent on redetermination, petitioner accepted payment without any protest and thereafter filed an application under section 28A3 of the Act. They are admitting that I received the compensation and submitted 28A3 representation within time. Only when, while receiving the compensation, I have not made any protest. That is only a legal point. My kindly submission is that the land single judge justice, Honorable Justice Sudarshan Reddy's judgment. I am relying on this judgment. also.
The language inserted in the section 18 and 28, one and same. Wherein it stated that any person who has not accepted the award. This has been interpreted by a full bench court at 2003, 6 AAT 353.
Supreme Court
Where,
judgment.
said that protest is not necessary.
Well, let him complete. Let him complete.
Supreme Court judgment at para number 6,
Para.
number 6. Having regard to the continuity of these plans in the High Court is correct in its valuation. This is the date of notification issued under section 4 of the Act is 4/10/78, while exhibit R6 is nearer to it, namely 16/8/2008. In comparison of exhibit A6 dated 14/1/77, inasmuch as the appellant have filed an application for reference under section 18 of the Act, that will manifest their intention. That was the observation of the Supreme Court, Honorable Supreme Court. No need to receive the compensation under protest. And kindly see, learn single judgment, Honorable Justice, this was extended this judgment. Land Acquisition Act, reference to court for determination of compensation, application made within time. Written protest not having been made while receiving amount of compensation awarded by the land acquisition officer, not a ground for not referring the matter to court. It is a direct judgment.
No. So is it this thing that you made an oral protest?
Oral protest.
Is it the case?
Legal notice, I said that we made a oral protest.
This is a case of even an oral protest is enough.
Legal notice, I said that I made oral protest. I submitted a written representation. Page number 22.
No, but is it the case set up by you that you had made, it's a case of an oral protest?
Oral protest, my lord. Page number 22, my
No, where have you said in the rate petition, oral protest?
kindly see page number 14, page number 14, para 4. Page number 14, para 4, affidavit filed in writ petition. I humbly submit that in pursuant to the direction of this Honorable Court, Revenue Divisional Officer, Adilabad, in proceedings number 18499, redetermine the compensation amount for which we are entitled to receive. However, the said redetermination was made ignoring several factors, and we have received the compensation so fixed under protest. Later on, we have filed application under section 28A3 of Land Acquisition Act dated 17/5/99, claiming that the compensation was not redetermined as per judgment of decree passed in OP number so batch and required under section 28A3 of Land Acquisition Act. The application was received in the office on 17/5/99, wherein we have prayed to pay the remaining balance amount with interest or to refer the matter under section 18 of Land Acquisition Act as provided under section 28A3 of Land Acquisition Act. So we have given representation on 17/5/99 and made several other oral representations by approaching the Revenue Divisional Officer of Hyderabad. No action has been taken in this regard.
Subsequently, there was again an award was passed by the proceedings by the RDO 18499. Please go to page 17. You have received compensation, that's at page 15, statement showing the amounts received along with the interest and scholarship.
18499 award is passed under section 28A. 28A award is passed. Thereafter under section 28A3 we submitted written representation and I also submitted oral representation.
No, you said that in the 1992 proceedings you received under protest, okay? Subsequent proceedings were given in 99.
No, my submission is that, Milord, it is page number 14, Milord. Page number 14.
Yes, sir, we have gone through that. Page 14, we have gone through that. That is your, in 93 proceedings, you received under protest. Subsequently, you made an application.
1993, there is no any proceeding. 1993, there is no any proceeding. 1993, we filed a writ petition seeking a direction to consider our representation under section 28A. That representation was considered following the High Court order.
In this order, is there anywhere recorded that you have received under protest? 18499.
18499 only order, that is only order. After passing an order, they give the amount and we received the amount. Thereafter, we submitted representation under section 28A3.
So these words may have been interpreted not accepting the award means not with many be like that not to film being people like 32 people. So they no agriculture is who will record. They are all agriculture related people and being employed. What is the any person not accepted the award? There's even written application. It doesn't say that not accepting the award. Not accepting the amount protesting until this is interpreted to mean so. This was sequel to the first class and this will be issued. Information the English not to export. People belong in space based on the conditions. The only thing we can say that one judge won't like they won't contest to saying that the amount of the student will not contested as an English. They have to stage. No, only within 4 days they have submitted. Okay. After thought, I think. Let's see. Ah, yes. Anything else? Yes, madam.
Your 20th has been award has been passed on 18499.
That
Compensation is on 35 and they made an application on 28 dated 17/5/99. The application is well within time. Only the ground on it has been discussed is that there was no protest. So the language inserted 28A3 and section 18 is one and the same. Wherein section 18 also says any person interested who has not accepted the award is that there should be a protest The 28A3 also says the same thing. Any person who has not accepted the award will get protest. But this has been.
So the see paragraph 6 of the judgment,
I'm coming. Only
Supreme Court.
this has been interpreted in 2003, 6 bench, wherein it has been said if the application is made within time, protest or not protest is not the criteria. It has to be done. It has to be. This is the judgment.
This one.
That's what I was saying. That's not was the case.
Page,
Yes, I just passed one judgment.
page,
353.
you don't know full bench. In your favor, Mister. That's what we were discussing. I told the brother that this is what the section doesn't say so, and she cited this judgment.
It's being dealt in section 88, but the principle applies one and same because the language insert language to both.
Which para, madam? Which?
Last paragraph, it has all the paragraphs, but the last paragraph, of the judgment.
Yes. But you should know full bench, right? Yes. Yes, madam. This intra-court appeal is filed against an order dated
Short synapses.
What would be case? What happened once it was reserved?
Yes, Manoj. It's without
Then
Manoj.
what happened? The release.
Subsequently, Manoj, Lawrence is really saying that it requires some hearing.
Oh.
To transfer one.
Transfer of the Learned, due to transfer of the Learned Chief Justice, it was released.
No, but it was reserved, right?
Yes,
But due to transfer thereafter, it was released.
This is February, March 22, 16 March 22.
Yes. The issue arises under the Public Rooms Act, The Airport Authority of India is the appellant before the Lordship. Airport Authority claims land in survey number 15.
One. Yes.
Yes. Well, the land survey number 15 of Begumpet village is being claimed by the Airport Authority of India. And the respondents are claiming survey number 19. There is no dispute about the land claimed by them, survey number 19 and 15. But in the guise of survey number 19, they encroached into the 15 is the case of the Airport Authority of India. It has initiated the proceedings under the Public Premises Act by issuing a show cause notice and passed an impugned order in the writ petition dated 26/4/2021 when ordering eviction. The order was challenged on the ground saying that the dispute is, there is a boundary dispute. Such a serious disputes cannot be considered under the Act 40 of 1971.
No, so what happened in appeal?
Well, petition is allowed in their favor.
No, appeal was
No
preferred.
no appeal is filed by them, no appeal is there. So, so CMA knows that
Filing an appeal, they straightway challenge in the writ petition. So single judges allowed it.
follow the writ petition. On the ground, para 17, your lordship, I kindly see. Facts, I'll take the para 12 later, para 17 is the reasoning of the learned single judge, page 28. All the judgment referred to so and so, there is abundant material to their plea that constructed the portions have fallen within the land covered by survey number 19 but not 15. When such a plea is raised in view of the judgment referred above, it is not open to the respondent to record the finding to the effect that such a piece of land covered by survey number 15 and order removal of construction by authority under the Act. The material based record on the so and so. When there is a bona fide claim of the petitioner with regard to their plea of constructions are in survey number 19 but not 15. Having regard to the plea, it is not open to the respondent to initiate the proceedings under the Public Premises Act. Well, the judgment relied by the learned single judge from 1982 onwards, on the judgment, you must know, Tumala Krishna's case, where a title and possession, long possession is there. The Supreme Court, Honorable Supreme Court, it's a complicated questions of law, title involved. Therefore, the party or a state has to approach the civil court. Here is a boundary dispute. I submit the Public Premises Act 40 of 1971 is a self-contained code. It has the powers of civil code, mappings of the civil code. Under section 18, it can summon, etc. And without section 15, there is a bar with regard to the protection of the public premises. Therefore, the authority or a tribunal constituted under the Act can decide the jurisdictional fact with regard to the public premises and can order eviction.
So what are the reasonings? You have only read conclusion.
Para 12 is a consent pleadings, I'm just coming. Para 12. Coming to the case at hand. It is a specific case of the petition of the flats in question are forming part of the complex construction survey number 19 of the Begumpet village. It is also their case that earlier said piece of land is held by so and so, which was given to his daughter named Kausama in Paspunkuma, and in a specific case of that more than 50 years it was in possession of either register and title in support of a claim. The petition also filed a public document, namely Kasa Pani for year 1954-55, subsequent Panis wherein Kamsama, as is shown as a possession of the land in question, covered by survey number 19. And all the Srimati Kamsama, after the said land was given to her, by Pasukukuma at the time of her marriage. There is an inference in the respondent with regard to the question of the Kamsama. She has filed a suit, which number 137 of 91, wherein written statement was filed on the defendant number 3. And the para 3 of the said written statement, it is categorically alleged that suit land does not fall in survey number 19, but is a part of survey number 15 of the Begumpet village. Though written statement is filed, subsequently defendant have not contested the proceedings in the civil code unilaterally suit was 137-91 decreed against judgment decree dated 16th July 1997. Though it is stated in the counter affidavit that the proceedings have been initiated pursuant to the survey conducted by the Assistant Director Survey Land Records, Rangare District, who addressed the letter dated 10th August 2000, but it was appears that said survey was conducted without issuing a notice to affected persons. When the piece of land was purchased by the petitioner and when constructions had already covered, survey conducted by respondent without a notice, the petitioner could not have been the basis for the initiation of proceedings against the petitioner. In reply, the affidavit on the petitioner, it is categorically stated the petitioner and other interested persons were put on notice, and there was no survey to their knowledge. I have also perused the various documents filed by the petitioners with regard to same premises. There was notice of demand of assessment issue of right from 1982. There is also an inquiry with regard to non-assessment property tax issue went out the petitioner on 13/11/2088. The very same premises was assessed property tax in the name of the petitioner vendors under the provisions of the Hyderabad Municipal Corporation Act. Petitioner has also placed a record notice dated 2/11/86 issued for assessment of the property tax with respect to the premises number so and so. At present, apartment complex has come up. In addition, same copy of the Casa Pani 5454 file, said Pani also Patrika, Mamila Krishnareddy, the father of the Kamsamma recorded the possessor, and the name one of the Alauddin as recorded, but even assessment subsequent Pani's Patrikas also name of the Kamsamma was recorded as actual possession of the property in possession covered by survey number 19. All these records are related to survey number 19 only, Lord. When a suit was filed by the Kamsamma 137 of 1991, respondent have filed a written statement with regard to the same premises. In their case, the said property was covered by survey number 15, but not survey number 19. In spite of them, they have not contested the proceedings ultimately superseded. In view of that matter, having regard the degree obtained by the Kamsamma, the went out the petitioner and abundant document evidence filed with the petitioner, it's clear. There is a serious dispute as consideration with regard to title and possession, land in question. It is also to be noted that several times respondent himself addressing authorities to decide the boundary dispute demarcating the land in survey number, which itself indicates about.
So on 14/8/2012, there was a direction to conduct a survey.
Survey is conducted, the report is filed, not. We have also filed before this honorable court. Report is.
We are only narrowing down the issue. We are only narrowing down the issue. The report. Report, madam. Sealed survey report. This is objection to survey report. Where is survey report?
Where?
You first see. See the cover. Is there any?
Okay.
Survey report.
What is the date of the report according to you?
I have one copy which had, in fact, I have given last occasion to the honorable court itself, my lord. My lord, the survey report, this is, my lord, we were claiming 570 yards, my lord. Yes, choose. Right. In fact, both of us filed objections also to the survey report.
Now change that. This is 15. This is TSHC, 15, so one report. Distinct, right? Distinct 15 and 19. 19 they show you, they are reversed. We should, 15, we should be able to take it. It's because this is nothing, we will see the payment, it is in 15. We consider this as. What is 15 is.
Report according to is in survey number 15.
Yes, sir. Their claim 19. All the document considered by the land single ledge are related to survey number 19.
Copy. So this the finding. Most of it is in 15. See the potential. This is my encroachment. Potential. We have to modify this report. This action. The order of eviction should be applied to the extent of this. 96 feet. This is. No, this thing. This size in 15 and 79.3 was in 15. Yes. So, yes, so then,
as
as per survey report, this thing.
79.33 square yards encroachment is there.
Ah.
But in fact, earlier survey report, 88/2000, under which the proceedings are initiated, when it was about 570 encroachment was given. On that basis, proceedings have been initiated. And we have also filed an objection, the respondent has also filed objection to the survey report, stating that we have stated saying that the lines instead of survey number 193, they have taken 192, thereby there is a wrong survey, that should not be acted upon. It's our objections for filed. But the question, the legal question which may fell for your lordship consideration is that whether
No, you are claiming right to remove any encroachment only on survey number this thing, 50. So as per survey report, 79.33 square yards.
Well, for that, we have submitted an objection because earlier survey given by the same revenue department for us on 8/8/2000 is for 570 excess. They are on that.
This which order? Survey. Order sheet you. Yes, mister. So, I mean, only that part of the area which is on survey number 15, you are you have the authority to take action.
My humble submission is, not subject to your lordship view. Not airport authority is claiming more excess land survey is not proper. Therefore, again will the matter be remitted to the authority. They cannot, now encroaching that and ask us to go to the civil court to establish a declaration. Lanaja says paragraph 21, I should seek a declaration. That's as a public premises. That's what Lanaja says in paragraph 21. Because of the boundary dispute. My submission, the boundary dispute is the tribunal which is act, it can decide it. This is not a dispute of title or possession. But we cannot be relegated to the civil court.
All right. Yes, Mr.
At page 6 of the additional material papers, which are filed along the written.
Yeah, what do you say with regard to this order and survey report?
Before I take to your lordship, the facts that which have led to the initiation of proceedings of summary remedy under the Public Premises Act is concerned, Millard. There is a decree, Millard, which is passed against him, and to the suit he is a party, and in the suit he claimed that the land does not fall in this and the land falls in their survey number, and despite that there is a decree, and after a decree.
Where is the decree?
That's the decree, Millard, is at page 214.
There is a decree against.
But I've stated paragraph that is discussed.
No, whatever. Is there a decree saying?
There's an injunction decree. There's an injunction decree. In respect of schedule, you will also see 15. Schedule in respect of survey number 19. That's what.
Let's see.
So that is why, Millard, he filed a written statement in the said suit. Kindly see, Millard, written statement.
No, what is the decree first? Tell us.
Please injunction decree.
Which page?
207.
207.
Third defendant is the appellant before my lord.
Injunction dated 16 July.
Yes, ma'am. And before that, Millard, there was a status order that was granted on 21/3/1991. That order was filed, Millard, in this compilation at page 96.
Where is the decree?
207, Millard, in read of number 1052.
20?
207.
Yes, we have got it. Where is the decree? Operative portion.
But the operative portion, Millard, not fine. Page 208, Millard, following. This would coming on with group final disposal in the present group. So the suit of the plaintiff. And the same is hereby decreed as per because explaining the defendant, the successor in office subordinate against the servant and henchman from interfering in the peaceful possession of the plaintiff in the suit scheduled property.
What is suit scheduled property?
Scheduled property, Millard, is at page 210, Millard. All that property bearing number 1-11 by 1E and the open land comprising of 189 square yards.
This is survey number 19.
Yes, my lord. Also.
Yes.
And kindly see, my lord, the written statement that is filed, which they did not file, I filed along with the written, along with additional material papers, page 1, my lord.
Yes.
Para 3 minute at page 2. But when I filed injunction suit against them, and it is the stand that they have taken, para 3, but from bottom, 6th line Miller, it is respectfully submitted. Flash back minute. It is respectfully submitted that as per the village records and map of the Begumpet village, the alleged suit land does not fall in survey number 19, but is a part of survey number 15 of Begumpet village, which belongs to so and so. Now, next one report is presented by, but it is their specific stand, even in the suit, that whatever I am seeking injunction is not that of 19, but it is 15, and that is their stand. But this suit has been decreed against them, and they have not chosen to. And after the decree, this is the decree which you will have seen in 1997. After 3.5 years of passing of a decree, but they sought to invoke the summary remedy under the Public Premises Act. But I have been in settled position so far as this stand. You will kindly see in the suit also there is a commissioner appointed for the purpose of survey, and the commissioner has filed a report mirror, and that commissioner report mirror you could find page 15 minute of the very same additional material papers, which he has filed. And the learned judge has referred to also mirrored that my clients have been in possession and there is a decree that is operating, and when they have taken a stand that the land in respect of which injunction is sought is not that of 19, but it is
Correct. So there is a decree of injunction in your favor in respect of land bearing survey number 19.
Yes.
Understood. Next, go ahead. So,
and commissioner filed a report, and in the suit IA 771 of 1991 minutes. That is at page.
So yes.
Page 15 minute, and in this he has surveyed, and page 17 minute you will find. It is noticed that one carrying whitewashing the newly constructed compound wall. When questioned him, he stated that he is an employee of one Arvind Kumar and the contractor of third respondent. The third respondent in the suit is the Airport Authority of India in that suit, and he was the person who was there. There is a compound wall, but then he is whitewashing the said compound wall, and this survey report is also filed before the court. And now, but after the decree, after 3.5 years, but they have released mirrored in the improved notice which was challenged before this honorable court, and they conducted survey. There is an encroachment of 569 square yards, and therefore they have initiated the proceedings. But this decree has attained finality.
We have understood, so long as decree stands, no proceeding under PP Act can be taken.
See that
Fine.
Large fine mirrored as the single judge has referred to. The factum as to my title on which I have been claiming, on page 20 mirror.
Page 20 of what?
Order which is given for my last. Then it will start considering the matter at page 12, para 12, at page 20 mirror.
Yes.
In the middle mirror, further when there is an interference by the respondent with regard to possession mirror.
Yes.
There is interference by the respondent with regard to possession of concern march. He has filed a suit in words and first one. A written statement was filed on dependent number 3, and in para 3 of the separate statement it is stated to be released that suit land does not fall in survey number 90, but is part of 15 of Begumpet village. though the written statement is filed, subsequently the defendants have not chosen to contest the proceeding before the Supreme Court and ultimately certain voice was decreed by a judgment deprecated. So and so. Though it is stated in the counter affidavit that the proceedings have been initiated pursuant to survey conducted by the Assistant Director of Survey and Land Regularity, where the requested letter dated 2000. It appears the such survey was conducted without any notice to the affected person. When a piece of land was purchased by the petitioner and when constructions have already come up, the survey conducted by the respondent without any notice would not have been the basis for initiation of proceedings against the petitioner. In reply to the affidavit filed under the petitioner, it categorically stated that the petitioner and other interested persons were not put on notice and there was no survey to their knowledge. They have also given various documents filed under the petitioner. With regard to the same premises, there were notices of demand for assessment right from the year 1982, and there is also an inquiry notice with regard to non-assessment of property tax to the vendor on 13/11/1982. The very same premises were assessed property tax in the name of the petitioner's vendor under the provisions of the Hyderabad Municipal Corporation Act. The petitioner has also placed on record a notice dated 2/11/1986 issued for assessment of the property tax. So, it will place the present apartment complex has come up. In addition to the same, copy of the Kasta Pahani for the year 1955 is filed. In the said Pahani Patrika, the name of Mamani Krishna Reddy, that is father of Kamsamma, is recorded as possessor. In the name of Aladin was recorded as Patada. In subsequent Pahani Patrikas also, the name of Kamsamma was recorded as person in actual possession of the property in question covered by survey number 19. And the suit was filed by the Kamsamma in was for 137 of 1991. The respondents have filed better statements and with regard to the very same premises, in their case, said property is covered by survey number 15 but not 19. In spite of the same, they have not contested the proceedings and ultimately the suit was detailed. In that view, the matter having regard to the degree of the matter of the petitioner and the abundant documentary evidence filed by the petitioner, it's a clear case where serious dispute arises to consideration with regard to title and personal land in question. It is also to be noticed that at several times respondents themselves were addressing survey authorities to decide the boundary dispute by demarcating the land covered by survey number 15 and well as 19, which itself indicates that there was a boundary dispute for land covered by survey number 19 and 15, and in that view the matter is an expert survey conducted. Respondents cannot be provisions on the mentioned that with regard to the applicable said legislation and provisions contained therein, it is designed and intended for authentication of questions in cases where there is regard to title and possession of the property in question. Powers conferred on the authorities and said legislation are only to order eviction and removal construction regard from the cases where there is a bona fide dispute with regard to title from the grant and that disputes are outside.
Yes.
Such disputes are outside the scope of said legislation and the authority constituted under the said enactment cannot be said to have jurisdiction to embark upon the domain of the civil code for the purpose of adjudicating civil disputes, the powers of which is exclusively vested in such courts, and it would be unreasonable to allow such authority to decide such disputes by invoking the provisions of the Public Premises Section of Northern Documents Act 1971, which provides for a summary procedure to conduct inquiry and order for eviction and removal of construction. In that view of the matter, if the said provisions are read with reference to the object of the legislation, it is clear that the said piece of legislation never intended to give its authorities the power to decide such complicated questions of title disputes, so as to decide the same by passing Article in Section 5. But this is what the learned syndicate has said, and learned syndicate has also referred to the judgment which I have relied on at para 3 minutes, the division bench judgment of Bombay High Court, which fell for consideration under the very same Act, Public Premises Act, wherein minutes the elections have regarded but last two sentences, the enactment is not so much concerned with the title as with the possessory rights vested in the central government and section 28 source by which such right to possession can be acquired. One such thing, the taking of premises on lease from its owner. And it is with reference to that. And when Tomar Krishna Rao decision which I should know 82, where a person is in settled position, he cannot be evicted by invoking the Land Encroachment Act. And then the single judge Lillard and Jharkhand High Court Division Bench in Sri Bajrang case Lillard, which you find at para 15, Lillard this also Lillard has para 14 and 19, para 15 Lillard. From what has been discussed and quoted above, it is abundantly clear that an authority under the Aforesaid Act has a very limited jurisdiction and has to determine only a dispute that may arise vis-a-vis services upon an application made for it has to proceed in a summary. The question as to whether area or part of so and so are not consequently making a particular is a question that will not focal point in this case. And then after 4 lines, the authority in the aforementioned case cannot be said to have jurisdiction to embark upon the domain of the civil court for the purpose of adjudicating an question of complicated title, which can only be done by civil court. It would be extremely unreasonable to allow court vested with a summary procedure to give a finding which can only be arrived at by a civil court having necessary jurisprudential competence.
Not necessary to go into all this. Yes.
And then you have to take the last 2 lines, catch words, page 26. Catch word that cannot be lost track of this provision are that all the estate officer is required to do is that he must come to the conclusion that a person is an occupation of an area which is already confirmed or which has already been declared. He cannot, nor does he have jurisdiction to identify a particular piece of property and then give a finding that the piece of property is a public property. But which they wanted to do mirrored in the present case after they have suffered a decree under the guise of mirrored unilateral survey notice that is said to have been done by them. And then mirrored the Leonard Single Judge also mirrored a judgment of Honorable Supreme Court in state of Rajasthan. But that is also a case where the Supreme Court was concerned with unauthorized occupants. Where there is a bona fide dispute, the matter cannot be decided under the said section by invoking provisions of the attack what. And then after you Lakshma kindly see and para 17 para 17 of the page 28. All the aforesaid record judgment support the case of petitioner as much as there is abundant material in support of their plea that the construction portions fall within the land covered by survey number 19 but not survey number 15. When such a plea is raised, in view of the judgment report we above, it is not open for the respondent to record a finding to that effect that such piece of land is covered by survey number 15 and to order removal of the construction by the authorities under the act. In view of the material placed on record on behalf of the petitioner, it is a clear case where there is a bona fide claim of petitioner with regard to their plea that the constructions are in survey number 19 but not in 15. Having regard to such plea, it's not sufficient to the respondents to initiate the proceedings under the Public Premises Eviction and Unauthorized Occupation Act and order for eviction. And you must kindly see para 20, para 21. This another argument that is advanced on behalf of the respondent that they cannot even go for a declaration when the learned judge said it is for you because there is a decree that is tearing and you can't unilaterally take that this is land in survey number so and so or so and so.
Yes.
And a submission was made that they would be prevented, they can't initiate the proceeding, they can't go suit for a declaration and recovery of position. But that was answered by Rajpet para 21 minute. though a further argument is advanced by the learned counsel for the respondent that in view of the provision under section 15 of the Provisions Act, there is a bar on them to approach the civil court. But it is very difficult to accept such a contention advanced by the learned counsel. As per the provision under section 15 of the Act, there is a bar of jurisdiction created on the courts only in respect of the order passed under the said Act. Upon a reading of the said provision, it is very clear that it creates a bar on courts to entertain any suit or proceeding in respect of eviction of any person who is in unauthorized occupation of any public premises or in respect of removal of any building, structure or picture of the goods, cattle or other animal, any public. But when there is a dispute with regard to title and possession of the very public premises, this bar created under section 15 of the Act would not come in the way of the respondent to seek a declaration with regard to title and possession in the event of any dispute with regard to the boundaries of public properties. As such, the contention advanced on behalf of the learned counsel cannot be accepted. And but of course, it raises as this court is of the view that the respondents are not empowered to decide such complicated questions of title and possession which are involved. Having regard to the view of the petitioner, the matters are raised to be quashed.
Yes. Yes.
And there is one more significant fact which also goes to show prior to that initiation of the suit in the year 1991, the respondent has initiated at the instance of the respondent a socio-economic survey was conducted and a survey report was given. But in that survey report, it is clearly held that there are no encroachments in survey number 15 in which they are claiming. And it is immediately then when they are interfering in survey number 19, this suit came to be filed. That survey report is also before your lordship. Today before your lordship, there are 3 reports. But one report which is filed before filing of the very suit itself, which is initiated at their instance, it shows that there are no encroachments in survey number 15, which is filed by them. And thereafter, when they are interfering, and this suit came to be filed, and to which in which they have taken that stand, and that was decreed. And in the suit also, the commissioner was appointed, and commissioner has also filed a report clearly stating that there is a compound wall newly constructed, and the land of the airport authority, there is a division by compound wall which was whitewashing at the time of conducting survey. But it is thereafter it was decreed, and after 3.5 years, then they have to invoke this proceedings. And the allegation in the impugned notice is more than 600 square yards is in our encroachment, and that was what was submitted before this honorable court when the matter came. And this is how the survey was ordered to be ordered to this honorable court, and the survey report came to be filed. But which survey report you last might have seen, and which is
now we have seen it.
yes, the finding is that total extent of schedule is 534.48, out of which 457.15 square yards falls in survey number 19, and 7933 square yards falls in survey number 15. This was the finding. And we have filed, my lord, our detailed objections to the survey report. You let me kindly see the objections filed by us.
Yes. Yes, yes.
And you let me kindly see up to para 3 minute, it is with regard to the earlier notification. So far as the appellant is concerned, para 2 minute at the end of at the last line of the appellant was northern neighbor of the said land. That is the land that being claimed by me. Northern portion I am claiming. And then you let me kindly see, I report to the survey report that is done in the suit, and then the their presence of contract from the correspondent. And though he was a party to the suit, but he did not choose to file any objections to the survey report that was presented before the court, and yes, there is degree. And then, so far as Para 15 minutes that it is submitted, there was an appeal pending between the appellant and some third parties regarding the land before the district collector. But this is a case which is pending against.
Yes.
This is an appeal minute.
So how much time will you take more? It's all we are in. We thought that you will conclude. That's why we. Yes. So yes.
Lakshmi, take a Monday minute.
No, not Monday. This today 2:30. You argue. All right.
2:30.
No, argue whatever.
It is submitted third appeal. There was an appeal pending between the appellant and some third parties regarding the land before the district collector Rangareddy in file number so and so, and on a direction by the collector, MRO conducted survey and submitted a report in his letter dated 1990, Special Deputy Collector, that no encroachments were found in survey number 15 and 16 of Begumpet village. It is submitted, the appellant issued impugned orders directing summary eviction on 2001, and then you last para 7. The appellant filed a lease letter stating that he is sending demarcation sketch of survey number 15 and 18 of the Begumpet. For the reasons best known to the appellant, the lease report was not disclosed in the impugned proceedings. According to the sketch attached to the said letter, the boundaries of Archana apartments are survey number 19 on south, survey number 15 part on northeast road and west. But this is the survey report which is initiated at their instance. In that survey report also, Millard, this Archana apartment was in existence way back in 1990, which was, Millard, which they have suppressed, Millard, in the impugned notice that is issued to me, invoking the provisions of the Act. These boundaries are contrary to the schedule annexed to the impugned proceedings in the writ petition. The appellant placed reliance on such report to sustain the impugned proceedings in the writ petition. The Leonard Single Judge did not accept the plea, as the lease sketch was prepared without notice to the writ petitioner and quashed the impugned proceedings on the ground of jurisdiction. And then, Millard, Lakshmi, kindly see, Millard, with reference to this survey report, Millard, I have filed objections from page 8, Millard. The Deputy Commissioner failed to take into account any of the physical features pointed out in the work memos were also filed, Millard. Work memo are at the time of inspection are to comply with the requirements of the work memo, including the localizing of survey number 15 and 19 by taking measurements as difference, that is FMB's development plan of GHMC and others. And you last knows, Millard, while conducting a survey, first the property is to be identified with reference to the FMBs. That is called T-funds. In the survey that is to be conducted, the survey that is conducted under pursuant to the direction of this honorable court, there is no FMB that is available with the officer, and we have requested him to first identify the survey number first and then go for the survey. And without T-fund, Millard, he states he has conducted survey, and the Deputy Commissioner noted at the end of page 1 that the Assistant Director has informed him that on verification of the technical records in their office T-fund, FMB and Setwar of survey number 15 of the Begumpet is not available. But the survey number 15 is being claimed by the respondent, and that FMB of the survey number 15 is not available with the another department of the government. But that is what is stated. In the middle of page 2 of the report, Deputy Director further stated that when the localized survey number 15 and 19, he stated, when we localized the survey number 15 and 19, we noticed that lot of changes were taken place on ground, like ground, big structure, building, etc. After the discussion with my technical staff, Deputy IOS surveyor and also with the appellant respondent decided to proceed to survey with ETS. It is nothing but left hand reverse to measure the horizontal vertical distance of angles. He repeatedly stated that both parties have accepted his decision to survey with ATS. The Deputy Director has wrongly stated that there are two methods to survey in the field. First method is recording the measurements, and the second method is capture of the ground figures and overlaying the recorded measurements, that is sequence village map. According to the Deputy Director, the Assistant Director, whose alleged survey is relied on by the appellant in the petition, failed to furnish the basic survey records, namely the Tippans and Setwar. In such case, any survey, particularly the fine action of fixing boundaries between two neighboring survey number is not possible without localizing the survey numbers on the basis of the landmark found in the village plan and taking the measurements from that point on the basis of measurements available in the T-pons. Firstly, in the present case, the T-pons are not available to know the actual measurement. Secondly, when there is a lot of changes on account of the urbanization after the preparation of the land record, it is impossible to identify the landmark and make measurements without taking into account and impact such changes. Further, the deputy director has called only the survey records pertaining to survey number 15 and not the survey number 19. The ETS machine is only an electronic device to measure horizontally and vertically the distances and angles, irrespective of the difference of the levels in the land and obstructions like structures on the ground. He also recorded there at the end of page 2 that there are a lot of obstructions and public floating on the record for the purpose of survey. The deputy director erred in saying that both parties agreed for identification as per the prominent points fixed by him and that he localized the survey number 192, 19, 15 and 18 of the Begumpet when he did not have the T-pons in all these survey numbers. Therefore, he has erroneously held that a part of Archana apartments, namely 79.33 square yards out of 36.48 square yards fall in survey number 15. But his superimposition on the Google map without there being any measurements, sketch or sequence of survey numbers so and so on the road development plan of the main Begumpet road from where he made drawing is totally unscientific. The road is more than 120 feet wide and was widened a number of times. The physical features existing in the village map are not taken into account, whereas his superimposed sketch which measurement shows that he stated from the end of the road. His location sketch on the Google map spreads well into the road itself. If the location sketch on the Google plan is also made from the end of road, then the entire structure would have been well within survey number 19. The deputy director failed to record the structures between Archana apartments and the compound wall of the appellant in survey number 15. This is the compound wall which has been recorded by the commissioner in the suit, and that commissioner report is also mirrored part of this record. And between the compound wall and Archana apartments also there are other structures, which is most crucial in the present case. The structures include a temple which is also found in the Google image filed by him. No claim is being made by the appellant in respect of the said temple which is outside their compound wall. It is most significant that this compound wall was built by the appellant itself as evident from the commissioner report filed in OS number 137 of 1991. In fact, in item number 5 of the work memo filed by the writ petitioner, the petitioner requested to identify the land in possession of the respondents with reference to their sale deeds, commissioner report and sketch dated 9/8/1991 in IA 771 of 1991, that is in the suit, and the entries in Pahani's revenue records for this
We
reason.
will continue at 2:30. It appears that you are interested in reading everything.
My NDA
Read. We will hear you at 2:30. Now we thought that 15, 20. We are hearing you for half an hour, more than half an hour. You are reading just.
No, my lord, I have
10 minutes.
points.
Fine. Continue. Yes, 2:30. You read according to your satisfaction, 2:30.
The survey determination or demarcation of the boundaries cannot be the only factor to decide the question of title as the long established position of the writ petitioners and their predecessor in title is not in dispute and is apparent by the unimpeccable land records right from 1954-55 Kasra Pahani till during the last during the last 60 years, which is much longer than the statutory period of limitation. Even assuming without admitting, but this is so far as even if it is in possession, the 27 of the Limitation Act would inure to my benefit. But so far as the title to the land which I am being claimed is concerned, but they have filed counter which is extracted by the learned single judge in the impugned order at para 5 itself, that they have not denied my right title in respect of the land which is being claimed by me in survey number 19.
They don't claim title in respect of 19 and you don't claim title in respect of 15.
15, that is clear.
And we can't decide title in 226. That is also clear.
I'm also not calling upon you. But my some humble submission is that when they have taken a stand in the civil suit, which is filed by me, in the civil suit they have asserted that the land which is being claimed by me is not that of 19, but of 15. 1990 itself. But had it been a case, but why they have not chosen to contest firstly the suit and allowed a decree to be passed against them and allowed the decree to attain finality and thereafter invoke the provisions of the enforcement tax for the
You are repeating, right?
No.
Merely because you told us that after 3.5 years of decree, they have invoked summary jurisdiction. All this you have
And
argued.
you will also kindly take up this act, but the object of the act, but some guidelines are issued by the authority from arbitrary use of this act in respect of the persons to whom the premises are given. But even in those cases where admittedly it is a land belonging to the authority and it was given on rent to their employees, by mere termination they can't take the law into their hands and invoke the provisions of this act. You will have to invoke the remedy under the law that you actually would find. I would only rely on the guidelines issued by them at page 4. May I request you to see.
Don't read it. Don't read. We will read the guidelines.
Page 4.
Don't read.
Class 3 Miller. Where a person in premises should not be
Public
treated or
Premises Act. Don't read, mister. We will read it ourselves. You have para 3.
Para 3. But it is in respect of admittedly their tenants to whom the land is given by the corporation.
Yes.
And by mere serving a termination, they can't take law into their hands by using this provision. You will have to go in accordance with the local law under which you are entitled to eviction. That is the understanding and that is how it is to be implemented and for which they issued guidelines. But here is a case where I am in settled position for the past 60 years and they want to invoke the provisions of this act against me, Millard, without there being a jurisdictional fact that on foundation that it belongs to them and having suffered that decree. Millard, that is my submission, Millard, and therefore it does not call for interference, Millard.
Yes. Anything else?
Please say when it is not a title dispute, it's a boundary dispute. But we can't file because of the 15A on a recovery position being the public premises.
Mark the presence. Yes, madam. Mark the presence. Arguments heard.
Item number 1,
Please.
Not admission into the PG college, not postgraduate, in private colleges, management quota, not application is made, not
Yes,
page number 18, Lord, application made,
page number 18.
18, Lord.
And
certified, Lord, certificates, Lord, received, Lord, page number, Lord, 15. And my full submission is not to receive my application, not for, not management quota.
yes. Ah. Not registered under why?
That the seats are available. Lord,
No, that means we can't. Which law says that seats are available, you should be admitted? Which rule?
But my application is there, Lord, this application, Lord.
No. So, what was the last date of registration? 24 September. Last date. He applied. He registered for which category? Competent quota means government. Now wants. So, when did he apply? 9-10. Not applied, but application has been filed on 9-10.
Yes.
So, what is it, Mr.?
Now, Lord,
Last date was 24-9. How can we permit? Why you did not apply under management quota?
right, in government quota, Lord, applied, Lord, this is not, Lord, in Karimnagar district.
So what can be done?
Personal inconvenience, Lord, now, Lord,
Personal inconvenience does not empower this court to issue any direction contrary to rule. They have notified the process of examination. Notified the process of filling up of seats. Last date was 24-9. You did not apply. What can be done?
But now,
Prepare for next year.
but,
You tell your candidate
existing seats,
instead
Lord,
of
many private colleges available, Lord, that's why, Lord, existing, Lord, colleges, Lord, seats, Lord, available, Lord, I will take whatever may be the, Lord, requisite considerations, Lord,
you will pay. So we don't give admission, mister. We don't run medical colleges. You are telling us that I give admission. I will pay. You will not pay us.
private
Right?
Management quota, that's all that exists.
We don't understand, right? We don't run any medical college. None of me, nor I, nor my brother. We are not owners of any medical. Don't give us money, and we can't give admission to you in any. We don't want any money from you. We can't give you admission in any MBBS course.
Oh, I'm saying colleges, Lord, medical colleges.
What colleges? Why it should be given to you? Which rule entitles, miss? You have not applied under this thing last date. Sorry. Yes. This petition mark the presence heard on the question of admission.
Page number 25.
25. All right, 25.
Page number 25, Lord.
25.
Page number 25, Lord.
25. Yes.
May I represent?
157.
Yes.
Yes.
May I represent, Lord? It is a writ petition filed against the order of mutation granted by the respondents for Sepshiguda, survey number 57, on the ground that there is a final decree in favor of the so-called persons. My lord, earlier to the litigation, a EP, a date was filed by the concerned respondents, which was set aside by the division bench. Suppressing the very factum, they approached the authorities by giving different nomenclatures, like that of
Order directing mutation of name. Appeal like or not? This is all mutation, right? Does not confer any title. I don't know what with so much of seriousness of this challenge. Order. So no appeal lies against the order of mutation dated 9/3/23. Only writ petition.
My lord, when there is a fraud on the statute, when the very final
That
decree was
alternative remedy we are talking about. Fraud on this, all points you can argue before appellate authority as well.
give liberty to me, my lord, I will file an application before them, fix a time framework, so that the appellate authority considers my
Under which provision?
the whole enactment of Dharani is made to.
I am an outsider, right? That's why I am asking you instead of giving you interested in speech.
Because
which act, Mr. Appeal lies?
Act has been repealed, madam. Now the
Under act, which act appeal lies we are asking? You don't know. Mr. Please help us, Mr. Senior Counsel.
a special tribunal has been constituted, madam.
Under which act provision appeal lies, Mr. I am asking you. Yes, please. Which provision appeal lies?
No, my lord, I will not be immediately able to say.
Well, state of Telangana has repealed the earlier Patadar Passbook Act 1971 and enacted a 2020 Act known as Telangana Record of Right in Land and Patadar Passbook Act.
Record of rights.
Record of Right in Land and Patadar Passbook Act 2020. Under this provision, the recording authority is the Tahsildar.
So against his order,
Against this order, appeal lies to a special tribunal under section 16.
16.
16,
16. Thank you. Special tribunal.
That special tribunal is presided over by the district collector and additional district collector.
Whatever. Thank you. Yes. In this writ petition, the petitioner has said
I request your lordship, my lords.
I am for the petitioner in this matter. Respondent has to file a counter, madam.
I request your lordship kindly grant 2 more weeks time for filing of
Learned
counter, my
counsel
lords.
for respondent praise warrant is granted 3 weeks further time to enable him to file. Yes.
The petitioner, my lord.
Huh?
The senior counsel is appearing through virtual mode, my lord.
My lord, I appear, my lord, for the petitioner.
Yes, Mr. Raghavan.
My lord, on the last occasion, my lord, your lordships were kind enough to pass an order that we had to file our reply to this office report. Today.
Yes.
The office report, my lord, I have seen it. It is a slightly complex report, and I want to satisfy myself that the reply that we file, my lord, is just and proper. And without that, I did not want to do it. So can I request your lordship to kindly accommodate me till 3rd of November? Before then, my lord, I shall do it.
3rd of
November, my lord.
all right. Let them.
My lords, as far as the report is concerned, the learned friend who is appearing for the, my lord, there is a apparent fraud. There can't be any nothing to be clarified with regard to the report called for by this honorable court.
No, Mr.
My lord, single officers of the court, my lord, any advocate can't support this type of.
No, not sub. See, if we act upon the report, the consequences are drastic. That order can be challenged in Supreme Court. You will not be able to defend it that they have not been given an opportunity.
My lord, correct, my lords. My lords, the honorable Supreme
There is no
Court
interim order against you.
My lords, the contempt case, my lord, the orders which have been secured, contempts were being filed. Contempts were filed.
No, so
The orders obtained, my lord.
what is happening? Like, I mean, we want to understand what is the objection in granting time to file objections. That's what we want to understand. You are saying that it should not be granted and they should be, what should be done?
My lords, the orders, the very cause of action invoked based on the fraudulent non-existing orders. Orders were made to be passed by this honorable court.
That's correct, Mr. What should be done today is you have seen that he is praying last time we had granted time.
My lord, since my lords, in identical case, the honorable Supreme Court itself.
In this thing, this thing on your request, we have directed status quo to be maintained.
My lords, yes. My lords, now that since fraud has been evidently played, nothing required to be established with regard to the placing of a non-existent orders. My lords, the High Court, my lords, in an identical case where the Supreme Court, my lord, directed the registrar to file lodge a criminal complaint with the jurisdictional police.
That we will do provided they file. We are not saying that the consequences will ensue.
Yes,
but
yes.
Please understand, if we direct registration of FIR, he challenges the order saying that the High Court has not even granted me opportunity to explain. How will you defend the order, our order in Supreme Court? In no time it will be remanded.
The report, my lord, notwithstanding the versions of either side, your lordship will be, my lords, be placing reliance on the very report.
Of course, but this has to be done after we have granted you an opportunity also to file your comment. You say that this is correct and this thing.
We filed an affidavit.
He is praying for time.
My lords, subject to lordship, my lord said.
3rd November. Yes, Mr. Raghavan, you file it. So see how seriously your prayer for adjournment is being opposed. Please file it on or before 3rd November. Right? Yes. Yes. All right. All right. Described by an order dated 29/9. Yes.
There's only one other submission I want to make, my lord.
Yes.
By your lordship's earlier order, your lordship said even the state will be permitted to file an affidavit.
They have filed.
No, my lord.
What advocate journalist?
We have not received any copy at all.
My lord's copy is given. If it doesn't receive, we are
All right, fine.
to be raised.
All right.
He should, my lord, he should have it from the advocate on record who is assisting.
Yes, yes.
Yes.
We are not saying anything.
Yes.
On this. Yes. Next.
Great.
I beg to appear in this matter.
What?
This is a writ petition, my lord. The petitioner, on the basis of a final decree passed in CS number 14 of 1958, applied for mutation. Mutation in authority, my lord, is the Tahsildar, who is the third respondent. The matter is pending with the Tahsildar. Mutation order is not being passed, whether granting or rejecting. That order is not being passed on the ground that there is a government order which is at page 131. My lords may kindly see page 131 and 132. The composite state of Andhra Pradesh at page 131 issued GOMS number 1559 dated 19th December 2007. Paragraph number 4 of that. Government, after careful examination of the proposal of the Special Chief Secretary, hereby direct that the following lands be alienated in favor of APHB's Housing Board on payment of market value. The petitioner is concerned only with item number 2 of this table. The petitioner's claim is only in respect of survey number 124, Mangalpalli, Ibrahimpatnam. Well, this GO remained on paper. There was no alienation. There was no purchase of this land by the AP Housing Board. Thereafter, under the Reorganization Act of 2014, under section 101, all the government orders remained in force, composite states, for 2 years. And state of Telangana, has not adopted this particular order. Therefore, the prayer is that the mutation proceedings may be processed and finalized by Tahsildar without reference to this particular government order. That is the prayer made. Matter is coming up for the first time before my lords.
All right. Heard on the question of admission notice.
Please. To purchase the non-registration of mortgage deed in favor of JHMC. Petitioner applied for.
You are that flat?
Yes, non-registration of mortgage deed in favor of JHMC.
Nobody, the last date of hearing this thing.
JHMC, Lordship directed me to implement the JHMC, who is the
Have you served notice?
Petition was ordered last occasion.
No, have they been served with GHMC?
Yes.
Notice served, nobody is appearing.
Yes. That's the reason why last occasion your lord has allowed them implead petition.
No, mister. That implead is.
Before impleading also, notice was
No.
ordered.
All right.
They are not appear. Name was printed. After that, IA was allowed.
Who is
Make a mukid manner.
Who is this thing? Commissioner GHMC.
JHMC. He is only unnecessary is only beneficiary. Basing on the permission granted by the JHMC, the petitioner has to execute mortgage deed in favor of JHMC. He is the beneficiary. But basing on
So this mortgage, what you are contemplating in favor of GHMC, but they must accept it. We have to hear them.
Construction permission was granted. 10% of the built-up area has to be mortgaged in favor of GHMC.
That's fine. That is fine.
Basing on the letter at page 19, the registration authorities are not accepting.
That letter, my lord, was held for consideration before this honorable court, my lord, page 25. This honorable court, my lord, stayed that letter. But subsequent, my lord, in the very same writ petition, my lord, at page 25, directions were granted, my lord, for registration, subject to result of the writ petition. But now petitioner, my lord, wants, my lord, to register the mortgage rate, subject to result of the writ petition.
With regard to registrations in CS 14 minutes,
They should not object to. They should not object to. It should see because what this to which it is litigation. They could actually try to solve it. And
minutes with regard
is appearing. Will direct personal appearance of this who is not appearing from GHMC. Commissioner.
GHMC, my lord, only the beneficiary, my lord. The grievance
No,
against.
but mortgage is being executed against them in their favor.
Yes, my lord. They will accept, my lord, mortgage deed. If I execute, my lord, in mortgage deed, and I have to hand over to them, my lord, and then start construction. Before starting.
But within GHMC, this property comes under within GHMC?
Yes, Serlingam Palace, my lord, MAK Mukit, my lord, is there. Standing house, right.
matters with regard to registration minutes,
Not appearing. You see this list. Last date. He is not appearing. Yes. What to? It's not forcing to accept. No, but.
Already interim directions are granted, my lord.
I don't. What is the prayer made in the petition?
Lord, to register, Lord, interim prayer is, Lord, to receive and register the mortgage deed, Lord, submitted by the petitioner in respect of the plot number source. Without reference to letter dated 29/9/21. Lord, that letter, Lord, was, Lord.
Array, Mr. You appear for GHMC.
Sir, MAK Mukit is appearing, Lord.
We thought that he has started liking the atmosphere of the court. Yesterday only he was discharged, so today again he wants.
That is the
to
reason
come.
by seeing that case number, I rushed to this court. And I'm.
Rush to this. No, very good. Yes. So.
It is their benefit, Lord.
Not your lordship.
He wants to create an asset in your favor. Do you have? We don't know.
this matter.
Creating a mortgage deed.
After execution of mortgage deed, Lord, I have to start the construction.
Then what happens supposing if this you will demolish it also, right? Your own expenses.
Construction permission was granted by them.
No, sorry. This is a subject matter of a civil suit pending before this court.
Yes, Lord.
Supposing if that decree is passed against you, I mean, we don't know. We are just asking, Mr. Supposing if that some decree is passed against you, you will, this thing like super tech, you will, this thing, call an expert and demolish it by this thing, every undertaking. And file an affidavit.
Final decree was passed in favor of the Millard, defendant 206 in this Millard. 206 executed registered sale deed. But I will not claim any, this Millard, I will not just make kind of record that.
He will sell.
I will not claim any equities, Millard.
Are you constructing for your personal use or you want to construct, sell and go?
Millard, for personal purpose, Millard, now.
Yes, you have objections.
Let them file affidavit saying that.
What
Let them file that not, they will not claim any equity in the case.
But I will not record it, Millard, in the order itself.
With regard to minutes, registrations in CS 14 minutes, Honorable Special Division Bench minutes.
Please make a extent. He is hurrying the communication, let's see his footprint. Suppose any adverse or response. I should ask him, ask whether, ask. No, it.
Page 25, Millard, is the order, Millard. That this honorable court suspended. the-
No, what happens when, like, supposing if any order is passed contrary to your interest in CS 14?
Lord, that's the reason, Lord, I will not claim any equities.
Not. But why? You will, this thing, you will sell it and you will get away with it, something like,
Lord,
you will construct.
for selling also, Lord, that will be subject to result of the writ petition.
No, why others should suffer? You will not tell them writ petition is filed. You will, why should we permit this? And why it should not be deferred till this thing, CS 14?
Here, Lord, in respect of this property, final decree was already passed, Lord, in the year 2010.
When?
2010, Lord.
Where is the copy of?
Lord, final decree was filed, Lord.
As on today, there is no final.
Lord, page 57.
Yes, council, any appeal preferred on that?
It's a only compromise decree, my lords, is not binding on the state government, my lords.
No.
Final decree was challenged.
Have you preferred any appeal, any
As
appeal
on
pending on it?
today, my lords, matter pertains to Hafiz Pate is subject before the Honorable Supreme Court, my lords. Survey number 77 to 80, my lords.
Why didn't you file counter to that?
We have already filed counter affidavit, my lords.
Page
Last week,
14,
my lords.
Page 14 is the appeal filed by them.
I have raised the order passed by special division bench in page number 224, my lords.
No, Mr. What is, like, why, on what ground you are opposing the prayer to register the mortgage deed?
It's a government land, my lords. It's not a private land, my lords. And large extent of land.
Is it prohibited from registry under 22A?
Yes, my lords. Yes.
Then it can't be done, Mr.
Lord, a letter was given, Lord. Page 19.
No, if it is in the prohibitory list under 22A.
7.
Lord, is Lord prohibitory list. A letter was issued, Lord, page 19.
What, Mr. In facts, there should be no dispute, right?
Yes.
Is it in the prohibitory list issued under 22A?
No.
No.
A letter was issued,
Letter
Lord.
was communicated.
Saying yes.
A letter was issued, Lord, page 19. Page 19.
Is it there in the list, Mr.?
Yes, my lords. I have filed that.
Page 19.
19 minutes.
Page, there is no notification prohibiting, Lord, under 22A. A letter was issued, Lord, page 19. That was challenged, Lord, by Lord, saying that the lands are covered by CS order not to entertain any registration. That is, Lord, page 19.
In identical matters,
That
my
was,
lords.
Lord, fell for consideration, Lord. That was challenged.
Identical issue, my lords, with regard to registrations.
Page 19.
See,
letter was
counter,
challenged.
no,
Page-
1 minute. Page,
page-
have you gone through the counter filed by them?
Yes,
Page 226 is some order by a division bench.
yes.
What is that?
That is, Lord, relating to, Lord, the letter issued, challenging the letter issued by the
Registration of
solicitor.
sale deed.
Lord, issued-
Please see, Mr. Please see. It's an order by a division bench. Why we should not pass a similar order? Please tell us.
Lord, there are other orders, Lord. This is, Lord,
Please, brother, you are part.
challenging the letter, Lord,
Tell him, please.
issued by the Tahsildar, Lord. That is different.
No. The subject matter of the property is same Hafiz Pate.
Yes, ma'am.
Please read the order, sir.
Yes, ma'am. The challenge there is, Lord, letter dated 16/6/2017.
Maybe subject matter pertains to Hafiz Pate, my lords.
You are a standard, we need not hear you. Your argument is 14 of 1958. We need not hear you. We know what will you argue.
My lords.
See, here in this case, the sale deed has been, registration of sale deed has been prohibited.
Yes, madam.
Any registration, mortgage sale or anything.
Counter.
Everything is same order, right?
That's the
You
reason.
can't deviate from our earlier orders.
By way of letter, Lord, there cannot be any provision. Only by way of notification, Lord. That's what will bench of this honorable court, Lord. If 22E, Lord, 1E. That was considered, Lord, by this honorable court, Lord. The page 25, Lord, order.
This relief in this case was also for registration of sale deed.
Yes.
That has been declined. See, mister, that's the difficulty.
Their challenge is, my lord, letter issued by the Tahsildar, my lord, in the year 2000.
Whatever, the relief is same. Registration of document.
Here, my lord,
There is something like when we grant similar orders, Supreme Court says similar order should receive similar treatment. Like we cannot take different view in different cases.
it will, my lord.
You tell us 220, what happened to this order? Has it been challenged before Supreme Court? What has been done?
I don't know.
Find out.
Place 20.
Maybe the SLP is pending or there is a stay, something, we don't know.
But their petitioners are not interested, my lord. That is the reason why, my lord. Page 19 order, my lord, was challenged, my lord. Page 25, your lord, please.
At the most, you can await for the report. Instead of passing order now, you can await for the report.
Again, that's the reason, my lord, subject to result of the writ petition, my lord, let it be, my lord. Registered mortgage rate.
No.
That is subject to, my lord.
Everybody will feel subject to
The very same survey number, my lord, page 25. The letter, my lord, was at page 9.
No, what happens to this order? You are not answering this. That means obviously you don't have an answer. The division bench has taken a view. What can be done? Yes.
That is 2017 order.
It doesn't become different like if it's 23 order. You cannot argue like that was 2017 order. I am challenging order passed in 21. You can't do like this.
Challenge is, my lord, 2017 order. My lord, very same letter, my lord, page 19, which is challenged in this writ petition.
Yes.
Page 19, my lord.
But this petition is still pending. Now what you are referring to page 25, it's still pending.
Still pending, my lord. There was a direction, my lord, to register subject to result of the writ petition. My lord, 15/9, my lord, after filing of counters, my lord, orders were passed. In the very same writ petition, initially, Yukund order was stayed. Thereafter, my lord, at 15/9, after filing of counters, the very same counter which now filed, my lord, was filed thereafter. There will be an endorsement, my lord, then there cannot be any further sales also.
Should we ask them to file and if they will not claim any equities, they will come with a decision.
Subject to result.
You first file an affidavit that you will not claim any equity, you will not sell it. No. You file an affidavit so that learned counsel for the petitioner pays.
Three eleven.
311, list on 3rd November.
You also file your counter.
Yes.
Hmm. 165, I beg to appear in the.
Yes.
But this is a matter of illegal interference by the official in the private land of the petitioners. But the vendor of the petitioners got grant assignment made by the government to the in the year 1987.
Subject matter is copy of the order is. What is this all? This is the injunction, right? So let them file reply counter.
already they have sought adjournments for that flood and
No, not adjournment. And this has come up for this thing. 25/9/2023 division bench, there was a direction, it has come up now before division bench. What three?
It requires the count.
It's a petition seeking injunction. What else? Let them file counter. Learned counsel for respondents pray
In this writ in this writ petition by
No, what happens if the mutation is made subject to decision of the CS 14?
yes, well, Supreme Court ultimately said.
No, we are asking you. If the
This
order
matter,
of mutation is made subject to decision, mutation does not confer any title.
That's true. Law
Right?
will set it up.
If you have title, you will continue to be the owner. In any case, that question is pending. Who is he has the title according to you?
Well, that
According
order
to
is
you-
already there. That already order is there. We have mutated in this way. That's why subject to the outcome of the writ petition, we have mutated also.
No, my lord,
They have
after
carried out
judgment
the
of
mutation.
Learned single judge, after the judgment of the learned single judge, they have mutated, implemented the judgment. They filed a contempt appeal because a contempt case was also allowed by the learned single judge. Then again, my lord, they have deleted the name of the petitioner and recorded the entry government land.
No.
My lord, the act is Andhra Pradesh Record of Rights Patadar Passbook Act. My lords have seen that, my lord, in the other case, I will pass on the act. Section 12 says this will not apply to government lands. The area act under which
He is saying that it has been implemented, then there is nothing to.
Now, under contempt, he filed, my welfare has filed.
Under contempt.
Not contempt, we have implemented and their names have been reflected in the Pahanis as of now. Well, however,
again that is reversed by them. Pending
that I have to accept it. No, to my knowledge,
My lord, I have no cause of action. If they continue my names in the records, I have nothing to
let
say.
this writ petition, no prejudice is caused to my land funds council. My land funds.
Oh, he will not suffer any.
The fact remains is the fate of this mutation in the other CS number is hanging in the balance before the Supreme. When Supreme Court decides whether their name will be continued, their mutation has affected by deed and Tahsildar.
This matter has not gone to Supreme Court.
From the outset, I have been submitting.
No, so we will make it subject to CS 14.
Yes, that's my case is over.
Very complex problems.
Very generous, very generous submission, my lord, of
He
the
made such an attractive paper
Yes.
book and got the relief from the court. So, it's being disposed of in the manner he wanted. Right. Mark the presence. With consent of the parties.
This entire order, it is cannot be enforced because it's a fraud made upon the court in the form of suppression of facts. But you lot give me 2 minutes. Well, I want to file independent writ appeal. The next matter is a writ appeal filed by me.
Writ appeal.
He is not a party, my lord, in the writ petition.
No, but yes, filed a.
No, he filed a petition for implement in this
No, but
particular writ
see,
appeal.
once like government has mutated the name of
No,
the
sir,
appellant.
today, well, no, today also it says that government lands only. That it says government lands only. My lord,
That it has been mutated under threat of contempt. So see, now you have again this thing. He says you have again deleted.
no, my lord, in the writ petition, my lord, I had filed an IA to impede myself. Without even considering that IA, order was passed, impeded order was
Right, so
passed.
what is your challenge to the?
They don't have a title at all. In fact, there's an inquiry order.
No question.
I'm saying inquiry was ordered. That was suppressed. In fact, your lordship have dealt with this matter. I'll just pass on, my lord, then your lordship might decide.
What is this passing on?
Well, it's synopsis. It's synopsis. The way you give synopsis, I was giving synopsis. Simple as that.
Supply him a copy.
I'm giving him. I'm not that I'm not giving
No,
synopsis.
no, he will give me later, my lord, after the court.
He's giving a.
No, sister, he knows that we require more time than you, so therefore he is giving us before.
Well, I have to first passing out the court and
Let him tell the court what exactly is his right over this land.
yes, but I'll exactly accept, my lord.
Yes. Yes, please.
But synopsis, my lord, your lordship. List of dates, second page. My lord, in the year 9, this same subject matter, my lord, 24 acres, 35, on the survey number 37, I have purchased under registered sale dates of 1981 and 20. Same land. We have a registered sale dates. Then, my lord, against the same people, all legal heirs of same Nawab Kaisuddin Khan. My lord, government filed an application, they lost up to the Supreme Court, my lord, government's claim is gone. Then your lordship may come to serial number 6, my lord. My lord, the vendors of the respondent herein, the writ petitioners, my lord, they purchase are supposed to have acquired the rights under unregistered assignment deed. Unregistered assignment. Then, my lord, this subsequently they filed an application and the order was passed. My lord, this mutation was ordered, and your lordship have seen that 6/5/2009 order became final. That your lordship could get it. Page number 4, serial number 16, my lord. That's where last time your lordship asked a query, what was the ground? 6/5/2009. That's where the suppression happens, my lord. 6/5/2009. Serial number
6/5 to
the mutation order, my lord. Serial number 16.
Yes.
6/5/2009.
Yes.
Your lordship last occasion said that has become final. What remains? But subsequent events have been suppressed before the honorable court. That's what I was trying to say. But after 6/5/2019, my lord, your lordship sees serial number 18.
Yes.
But serial number 18, Commissioner of and Inspector General of Registration of Stamps, while memo dated so and so, the Director of District Registrar to cancel their sale deeds, my lord. They directed to cancel the registered sale deeds. Agreed by this, the writ petitioner filed a WP number 12091, that's serial number 19, my lord, was suspended. However, liberty was given to conduct inquiry with under section 82 and 83, serial number 19. Then, my lord, serial number 20, B5, after impeding because all the sale deeds were executed in my favor, subsequent double registration. My lord, separate writ was filed 27045. I filed writ petition saying that once a registration has happened, there is nothing but a double registration, therefore it has to be cancelled. Then Honorable High Court directed, my lord, saying that district collector to conduct inquiry and submit a report regarding double registration on serial number 28. Then, my lord, your lordship may come to page number 12, serial number 21. The writ petition issued a notice, and then they filed on serial number 22, 2nd June 2014, they filed a writ petition to affect the mutation in their favors. This serial number 22 is the one, my lord, which is the improvement order, my lord. But serial number 18, 19, 20 been suppressed in this writ affidavit. Serial number 18, 19, 20, that's Commissioner of Inspector and inquiry being conducted, cancellation of the sale deeds, everything has been suppressed. Then, my lord, on 8th June, we filed an implementing application, said writ petition by WP and NP number 24865 2014. Then your lordship may come to serial number 24, my lord. Your lordship will see the note in the serial number 24. This honorable court in said order records that report of district collector clearly pointed out grave illegalities in processing and registering the sale deeds of the writ petitioners and accordingly recommended to the Inspector General of Registration and Stamps to take consequent steps for cancellation of the sale deeds. So the sale deeds are directed to be cancelled also by this honorable court.
Cancellation of registration.
Now, my lord, these aspects have been suppressed before the learned single judge in the writ affidavit. So when I wanted to bring my notice by filing an IA to impede myself, my IA has not even been either allowed or rejected. So therefore, I have to file an independent application, my lord. Now, my lord, this serial number 20, serial number 27, my lord, is the improvement 17th March 2006. 2016, 17th March 2016. My lord, from serial number 18, 26 have been suppressed in this before the learned single judge. My lord, suppression of the facts, especially before the judicial court presents, my lord, are important. My lord, your lordships had an occasion to deal with such kind of suppression. Few judgments on which I rely upon, my lord. Sir. My lord, these are proposals on which I am relying upon, but your lordship may come to judgment number 5, my lord. Judgment number 5. My lord, page number 56, para number 26, my lord. Your lordship had authored this judgment, my lord. May I read that one, para 26? At page number 56. It is a fundamental principle of law that a person invoking the extraordinary jurisdiction of Article 2 of the Constitution of India must approach the court with clean hands and should not consider the material facts. It has been further been held that there is necessity to save the judicial process from becoming abused to support of justice. The need to approach the court with clean hands is all the more necessary as the law is not a game of chess. Then 27, my lord. In the instant case, petition 15 in the writ petition was aware that petition was not aware about the notification dated 25/4/2005, notification dated so and was not served with any notice with regard to acquisition of notice at any point of time, and learned about the same only on 4/5/2019 when the respondent number 2 and 3 issued a threat of demolition. This matter was suppressed in the writ affidavit. Well, your learned judge, your lordship had also had occasion to deal with the sitting in a division bench, page number 58. Yeah. Page number 58, the case of N. Ramaraju versus Principal Secretary Government of. The lordship may come to page number 84, my lord. Page 83 bottom. And identical facts, my lord. Whether the appellants are guilty of suppression of material facts. The lordship held, my lord, it is fundamental principle of law that a person invoking extraordinary jurisdiction under Article 2 of the Constitution of India must approach the court with clean hands and should not consider material facts. It has been further held that there is a necessary same thing. The necessity to save the judicial process from becoming so. Becoming abusive to subvert the justice, the need to approach the court with clean hands is all the more necessary as this foundation. Then B is also your lordship note. It is pertinent to note that liberty was granted to the husband of petition number 2 in WP number so to approach the state government with regard to the agreements. However, none of the appellants have stated in the writ petition that the liberty was restricted to appellants in WA number so, which was disposed of on 24/3/1988. Some of the appellants who have received the complaint are also parties to consent awards have not stated the said fact in the writ petition. The appellants have also suppressed the fact that the portion of the land in question has been taken from them. Thus, the finding recorded by the learned single judge that the appellants are guilty of suppression of material facts is affirmed. So, my lord, your lordship would have taken a consistent stand. If there is suppression of fact, then they are not entitled to invoke the extraordinary jurisdiction. Normally, if the same facts of suppression were brought before the notice of the learned single judge, the learned single judge would not have ordered notice. Their salients are itself sought to be cancelled by the order of this court. But there is one more judgment, my lord, which 7 judgment, sir. Your lordship may come to judgment number 7, my lord. Page 88. Page 88, the judgments are Rajkumar Soni. Page number 93 onwards, para 10 onwards, referring, my lord. Page 93, my lord, para 10. I'm relying on para 10.
Great, madam. Oh, para 10, yes.
The para 10 is related to facts of this case, but I'll not trouble your lordship on reading the facts. The lordship may come to para 11, page 94, placentum P, my lord. It is fundamental principle of law that a person invoking extraordinary jurisdiction of the High Court under Article 2 of the Constitution of India must come with clean hands and must make a full and complete disclosure of facts to the court. Parties are not entitled to choose their own facts to put forward before the court. The foundational facts are required to be pleaded, enabling the court to scrutinize the nature and content of the rights alleged to have been violated by the authority. The appellants in this case fail to establish they have lawfully secured allotment of land. It is a duty cast upon the appellant to plead and establish their order of allotment granted to the subdivision officer in favor of the predecessor in title, any right and so. Now, in this case, in such view of matter, we are of the opinion that justice has been done in the matter and High Court has rightly refused to resurrect the order of the subdivision officer, which is unenforceable law. Now that 6/2009 letter, notation which they are trying to implement it, enforce it, matter has been obtained based upon a sale date, it itself has sought to be cancelled. Now, by virtue of this writ petition, they want to resurrect an illegal order. Therefore, my lord.
No, but that order narrating mutation stands, right?
Yes.
My lord, that's a college. Mutations happened based upon a sale dates, which are directed to be cancelled. It's only, memo is only for mutation. Your lordship would already rightly said mutation does not confer title. But the issue is, the orders of mutation have been obtained on the basis of a sale dates, which have been obtained by fraud, a double decision. This honorable directed cancel the sales.
No, it cancelled registration of sale deed.
But your lordship cancel the registration, my lord.
Registration.
Cancel the registration. Once the registration is cancelled, sale is no more valid. So now by what?
No, it can be an unregistered deed of sale. What is?
Unregistered mutation cannot happen, my lord. That's the only thing.
No, but see, this Supreme Court itself has held in SP Anand that the High Court under Article 226 cannot declare a sale deed to be void.
Yes.
My lord, that order has not been challenged. That order, my lord, there are two things.
No, see, Mr. There are two different tasks. Please listen. Two different. You have written in your note. We have not gone through the. We are only reading the note which you have given.
Yes, ma'am.
It says cancellation of registration. Cancellation of registration of a sale deed prima facie may not amount to annulment of the transaction itself.
My lord, your lordship, because that Supreme Court judgment which says if there is an infraction of the rules and regulation by the registering authority in registering a document, that part of the action can be challenged.
And that document can again be, supposing procedural
That can be
infraction, again the parties can present it for a fresh registration, get it registered.
Now, my lord, today, that order has been passed by this honorable court, my lord, saying that that action is wrong, therefore the registering has to be cancelled. That portion, my lord, is still invalid, that's in force.
No, this thing, let us understand, there is a direction for cancellation of registration.
Cancel of registration.
Correct?
Yes, my lord.
Whatever effect that we will concede.
So, now, apart from that,
and according to you, that fact he has not disclosed, therefore he is not entitled to relief under Article 226.
Only thing, my lord, when your lordship are concerned that in writ of appeal, if these facts from serial number 18 to 26 were brought before the learned single judge without suppressing that, whether the learned judge would have passed this impugned order or not.
Yes.
That is one point which has to be got. Well, same note, my lord, your lordship would take that note, your lordship, same note, my grounds, 5 grounds I have mentioned. The page number 6 of the note, my lord. Number 1, my lord, implead petitioner has the prior purchase 1981 itself. I have a registered sale deed. There is an unregistered assignment deed. That's first ground.
2002.
Second ground is, my lord, admittedly through unregistered documents, title will not pass in respect of immovable property. That's my second ground. Section 17 is the compulsory registrable document and section 43 of Transfer of Property Act. Then, my lord, number 3 is orders in WP number 15056 obtained by suppression of fact, which I have already been canvassing from submission. Fourth is, even the mutation order has been obtained by paying fraud. I can always set up even in collateral dispute that it cannot be enforced. Then our fifth one is that already I have said it's cancellation of, there's a direction to register and cancel the registration of the document. So therefore, my lord, this is apart from the inquiry which has already been conducted in the 82 and 80 regarding the sale dates. So in these circumstances, can the name be mutated? When I am prior. So when your lordship is saying it can be mutated, result, but issue is, my lord, can the name be mutated when they have obtained by fraud? That's my submission.
No, but was your name there in the revenue records? No.
My lord,
Your name was there in the revenue records. No, what has happened is that his case all along was that whatever he claims title, there is an order by the revenue authorities. His grievance was that the name of in the revenue records, this thing title of government is shown, and he was seeking mutation.
That's the only thing, my lord. When you come to lordship, come to point number 4, the memo was issued by government to in 2004 to.
But on the supposing if you have title in respect of land in whatever your manner you have pointed out by registered sale deed, you are free to initiate.
Mutation, no, I'm here only in mutation, not on title, my lord. When your lordship comes to page number 7, point number 4, there's only small one paragraph.
Our query is that have you initiated any proceeding for mutation of your name? Or any or is there any document showing that your name was already there?
No, my lord.
And it has been deleted and government has recorded its name.
The government has issued a memo in 2004 to mutate my name in the revenue records. That is where the fraud has been paid. That's my point number 4. Your lordship may, point number 4, and to substantiate this, your lordship may come to page number 37, that memo in writ appeal filed by me, filed by the government itself, 579. Writ appeal 579, page number 37. Now this dated 5th November 2004, my lord. They were not purchased by that date, 5th November 2004. Now your lordship may come to para number 3, my lord. Third line, fifth line, para number 3, fifth line. The Special Chief Secretary and Chief Commissioner of Land Administration has stated that it is clear that no useful purpose will be served in pursuing those cases any longer, and also stated that there is no option left to the government except conceding the request of the purchasers from the decree holder to effect the mutation in their favor. Purchasers as on 2004, you are the only the impeding petition, except them, there are no other impeding purchasers.
We'll continue on Monday, Mr.
Mallards.
Now we have two other cases also.
Yes.
List for further hearing on Monday. Monday is what date? 60. No, actually we would have responded, but yes.
168 to 169.
Alert, my grievance is only this, my lord. I am the writ petitioner. I have not argued. All others have argued. And they have submitted synopsis across the bar.
So see, I mean, you must infer from this that they concede that you are this thing, from all this, their conduct, you should infer that you have an excellent case. So they are not permitting you to argue and explain it.
In the middle, my lord, the other person, the third party has come.
That's why we have fixed it for Monday, mister. We will hear you on Monday. Yes. Yes.
168, 169, Millard, that's the candidate take up on 311, Millard, senior.
Okay, 168, 169 list on 311. Huh?
Two applications for next week.
Which application?
CS 39
Which case?
for next week. Pension memo.
Mention? Oh. In the middle now. All
What
right,
is the-
next week. Next week. All right, next week. Yes. Hey, ask him to sit down. Why to take trouble? He's arguing. Please sit down, mister. Please sit down. There's no need to. Please. Yes. Yes.
May please your lordship. Let's CCCA 129 and 130 are preferred by the government without challenging the order.
Which is 2012. This has to be heard by us. It is what date? In a weekday we list. 211. Let's say he's saying that. So shall we take it up on 30th October? On a weekday, not
On a
like this,
weekday.
it can't happen.
This for the
It
request.
can't be taken up on a Friday, mister. That's what we have realized. We will take it up on 30th October, Monday.
Yes.
Correct? Monday. So that it comes up like 2012 matter, it will come up high on the list.
Lordship, we take it right from 10:30 itself.
No, not 10.
These are first appeals. It takes 2 days continuous from morning to evening. You have to read the entire evidence. There are a number of.
Let us see. We sincerely want to begin. That's why we are not 10:30 because there are some other cases also.
Lordship, we have it in first week of November, otherwise it was 30th, 1st October.
All right. So 6th November.
The whole problem is
1 minute. 6th November. Monday.
why I am submitting like this. The page failed because the government repented. This matter arises out of CS 14. Therefore, you will also have to look into CS 14 matters, all the entire record of the how the matter went on from trial court here up to this court here. CS 14 matter. So that's why it's
Can't be decided.
The genesis of this suit, my lord, the plaintiffs are claiming the genesis basing on CS 14 decree and assignment.
Yes, so what is the submission is that till CS 14 is decided, it can't be taken up.
Exactly, my lord.
Huh?
That is how it is, my lord.
So then we will adjourn that.
the CS 14 record will have to be looked into. That's why.
So then we will have to adjourn then it's your submission. What do you say? He says that till CS 14 is decided, this appeal can't be heard. What do you say?
In fact, there was a direction to remove the names of certain persons. HIGHCOURT did not do it. There was a direction to collect the amount in the bank, etc. for final degree. It was never done. There has created further complications in the matter. I'm sure that.
Huh?
Explaining.
What is your submission? What is we that CS till CS 14 is decided, this can't be heard. This what you sub.
CS 14 judgment, CS 14 pleadings, what happened in that matter is the base for this. That's why the matter is listed before this court.
Huh.
To be, because
So what is your submission? It can't be decided till CS 14 is decided. That's what you are saying.
I'm not saying it takes time. Okay. I will show all that record also before the court.
So we are fixing it on Monday. You said first week of November. We are fixing it on 6th November, Monday. Right? 6th November.
This was the precise request when I said it takes some time.
It can't be done on a Friday, Mr.
Yes,
we have realized it. That's why we are fixing it on a Monday.
Yes.
List this appeal for hearing.
Made, please. Made, please, my lord. Coming up for the first time, my lord, notice may be ordered.
174 to 183 notice.
Obliged.
Notice, personal notice, whatever, proof of service. 174 to 183.
Lord, I apologize, my lord. 178, my lord.
You want to withdraw?
Just one short submission, my lord. This is an application under 29A for extension of mandate. I'll take out
personal service, whatever we have said, get it listed
Lordship
when
may-
they are served.
Next week, Lordship may have it or else, sir.
You get them served.
As
176 list on, 176 list on that proof of service, etc. You write list on whatever next Friday.
Much obliged.
184.
My lord, I am appearing for the respondent. My lords may kindly consider granting me some time for filing counter in this matter.
It is being considered.
This is 22.
Oh, my lord, I have received.
22 matter.
I have received Parabai's remarks. Kindly consider granting some
Next
time.
week. Next week.
My lord, 2 weeks because it is from Andhra Pradesh. My lord.
What? Andhra Pradesh is not South Pole, right?
I'm not saying it's South Pole. Kindly consider it.
But this is 22. Please understand. The Supreme Court has said that the arbitrators are not appointed within a year. The very purpose is sort of frustrated.
It's not an arbitration matter. It's a contempt case.
Arbitration.
Oh, it's a contempt.
Kindly consider.
Learned counsel for responding. They will give a date.
Instead of the orders passed by the arbitrator, it was confirmed by the court.
He is entitled. Praise for and is granted 2 weeks further time by way of. Right?
Yes.
It's fine. Yes.
Please, your lordship, and for the petitioner in this matter, your lordship.
Ah.
This is an arbitration application. Your lordship, it's only the main purpose of the parties have not come to a consent of appointing a sole arbitrator in this matter, your lordship.
So all right.
Yes, my lords. The parties have been unable to reach on a consensus.
Fine. For whom should we appoint? Any former judge?
Yes.
Any.
This this petition under section 11 within bracket 6 of the arbitration
After the notices was served, none of them appeared before.
Nobody is appearing. Which is the this petition and none correspondent. What is the dispute?
Well, it's a dispute with respect to technological services. The agreement is at page number 21.
Which clause?
Clause 2, which is at page number 6.
Clause 2. Page
number 25.
25.
25 of the agreement.
What is the extent of the former judge of this court?
So I have suggested a district judge, document. It's a
Is
one
it
crore
what?
dispute.
Huh?
A dispute.
All right.
1 crore.
Yes. Next.
I'm appealing for the applicant.
The other side is not appearing. Huh?
I'm appealing for the applicant.
Yes, madam.
Lordship, this is the dispute which is arising out of a MOU, your lordship.
So other, this thing not appearing?
No.
None correspondent.
Obliged.
Disposed of. Yes. Hmm. What do you say?
I'm for the petitioner in this matter also, your lordship.
Ah.
Same
Yes, but
parties have not able to come to the consents of the sole arbitrator, your lordship.
no, that's correct. But he is opposing that there is no arbitration clause in the agreement. Where is it, madam?
It is there, your lordship, and there is a reply notice also been issued by.
Where is it? Which clause, madam?
Yes, your lordship.
Five. Huh?
Clause 5 of lease deed, your lordship. It's a registered lease deed. Clause 5, your lordship.
Yes. Hey, what is it, mister?
Page 28,
We have seen.
arbitrator or civil court.
Ah.
Some denying of the civil court judgment,
Option if in arbitration clause gives an option.
Yes. Further,
Yes, madam. Are you aware?
Yes, your
What is
lordship.
the citation?
28, your lordship.
Citation, Mr. Tell.
2007 ISCC 719.
5 SCC
719.
719. Correct. The arbitration clause has to mandatorily provide.
Yes.
Have you studied, madam, this judgment? You don't seem to have any idea.
The relevant para minutes is para 8 minutes and subparagraph 4.
Yes.
The lordship permitted the read. They relied on multiple judgments minutes and they said.
Where is that clause? Mandatorily it has to, it is said.
Yes, sir.
Which clause?
8th para subparagraph 4.
No, but these clauses are different than the one in the present
The
case.
lordship 9 minutes. 9 is the reasoning. There they referred there was a conciliation or arbitration. No?
Which? Para?
9 minutes. 8.4 is the parameter, 9 is the application of that parameter, which is 8.4.
No, where para 9 is para 16 of the partnership deed.
Your lordship sees because para 16 of the partner provided if there is any dispute touching the partnership arising between the partners, the same shall be mutually decided by the parties or shall be referred to arbitration if the parties so determine.
No. Mutually decide whether should be referred to arbitration or not. It does not, Mr.
Lordship further, the clause.
No, you understand the distinction, right? Yes.
That's all I'm saying.
This clause, this type of clause in your agreement has not been dealt with in this judgment.
There is a distinction given, because civil court and an arbitrator, when a notice was working arbitration, when consent was sought, I exercised my discretion and I said, I would like this matter to be referred to civil court. Because this agreement, it's not.
Yes, madam, what do you say?
Your Lordship, the page number, there is a reply notice from their side, Your Lordship.
No, not reply notice, madam. 2007, volume 5, SCC 719.
Kindly post it next week, Your Lordship.
Then in the beginning, you were not ready, you did not know, despite that you were.
Your
Lordship,
Lordship, there is a consent. There is a consent, Your Lordship, that there is a concern that they have not raised any objection while
We said
the notice.
We are not sitting here to explain what is being argued. If you are unable to hear, then it's fine, madam. I will decide it today itself. I mean, what is there? I'm not sitting here to explain to you what is going on in the court. If you can't hear.
Next week, I'll be present physically and I'll take it.
Learned counsel for the petitioner prays for adjournment.
I am for the response.
Hey, Mr. You tell her what is your objection. She hasn't got it, right? And again, next week she will again pray for adjournment. Yes.
I am for the response.
No, that's fine. What is the agreement?
For developing the property.
18.5. Which clause provides for agreement? Like turning pages here, right? What is clause 9? Yes, this petition under section 11 of the bracket 6 of the Arbitration Conciliation Act has been filed.
$50 lakhs is a dispute.
Former, and therefore, B. Satya, Shri B. Yes.
Your Lordships, I am appearing for the applicant in item number 190. I have filed a memo of service, Your Lordships, that said that.
Unserved. Unserved, madam. Learned in view of the postal endorsement that the notice issued to the respondent has been received back. Pad not authorized. Who is the counsel? Any person you will serve and stand, make him stand here. Oh, no.
Understood, Your Lordship. We'll take.
Personal service, personal notice, whatever, proof of service.
Very well.
Not served, the same order. Let, don't write no one up, let.
May it please, my lord. For the petitioner, there is an agreement between the parties, my lord, for technical assistance manufacturing agreement. So,
No one appears.
no,
This, yes, madam, right. Whole thing.
clause 24, page 24.
Clause 24, dispute between the parties. What is the,
Page 24, clause
what is the
7.3.
quantum, how much is the amount in what?
60 lakhs. 60.
Former, this thing, who?
Former judge, my lord, of this honorable court, Honorable Justice Rajshekar Reddy.
Justice A. Venkateshwar.
May it please. Respondent appeared, your lordship. They have not yet filed counter.
Let them not fight.
I have
Nobody is
filed,
appearing.
now I have filed an application seeking to amend prayer.
Why?
Now after filing the present application, there was a agreement for settlement. That agreement settlement I have filed before your lordship.
No, what, I mean, you don't want appointment.
No,
Now.
I want an appointment. This has to be, this particular para has to be added. Why? Because having settled out of
Third
court,
on ISO and so. Date you will use, sir.
2 weeks, your lordship. I'll file.
Oh, you first serve and then you can mention.
Yes.
Your Lordship, I appear on behalf of the applicant in this matter. The notice is unserved as refused.
The notice, the
I'm appealing for the appellant, your lordship, in this matter. Page 26, para number 24, arbitration clause is there, your lordship.
Opposing the application, your lordship.
No, they cannot oppose now. Arbitration clause is there, your lordship.
they cannot oppose. He can't appear.
No, he cannot.
What is this?
I'm sorry, your lordship. They have filed count.
No, we will remember your name and when you appear for respondent, we will say you cannot oppose.
No,
Write down his name, whatever cases he appears for.
Lordship,
Do you want to file any this?
No, your lordship.
Reply.
Arbitration clause is already there in this matter. I am relying on the judgment of the Supreme Court, your lordship.
What is this? Counter. You are giving something. Huh?
in fact, the purchase.
One.
Petitioner is around 75 years old, your lordship. They are
1 minute. 70, 85, supposing if he is 85 years old, therefore it is to be allowed.
No, your lordship,
That-
that is not,
and then-
these are the grounds can be, that are arbitrable. He should go before the arbitrator and do all this.
That you can't decide, that I have to decide,
Yes.
right? Whether he should go before arbitrator. You advise your friend, if he agrees, fine. I have nothing to decide then. You advise him, if he agrees, he has filed a counter.
Yes, sir.
I am going through the counter. Your argument is arbitration clause, that's all. Yes. So you say that this notice arbitration clause was invoked on this thing, 13/7/2015.
Yes, Your Lordship.
And you filed a reply thereafter, he did not take any steps.
No, Your Lordship.
And for after 7 years, he issued a notice.
In 2022, he issued another notice.
Another notice. Therefore, you say that barred by law.
Yes, sir. And the purchase orders, Your Lordship, are of the year 2011 and 2012. And admittedly, the last invoices have been raised
Purchase orders of 2000.
2011 and 2012. Date, Your Lordship. The purchase orders are 11th May 2011 and 12th May 2012, Your Lordship.
All right.
And the last supply,
Which is this purchase order contains an arbitration clause, correct?
the general conditions were annexed to the purchase order. Your Lordship.
General condition. Which is the arbitration clause?
Page number 26, Your Lordship, clause 24.
26.
Of the petition.
1 minute. 26. Clause 23.
Clause 20. 24 is the arbitration.
24.
23 is the
Yes.
settlement.
23. Clause 24.
Yes, sir.
All right.
In fact, Your Lordship, as just one other submission here. As per, according to the petitioner himself, Your Lordship, the last invoice that has been raised was submitted in August 2012 and August 2014.
August.
On 31st August 2012 was the last invoice submitted in relation to one purchase order, Your Lordship. And on 25th August 2014 is the last invoice submitted in relation to the second purchase order. Arbitration notice was issued on 13th July 2015, Your Lordship. Thereafter, no step. And in fact, Your Lordship, in 2000,
You had filed a reply to this, no?
yes, Your Lordship. On 22nd August 2015, a reply was given to the arbitration notice. Thereafter, Your Lordship, in 2018, the applicant issued a notice under the Insolvency and Bankruptcy Code, Your Lordship, to which a reply was given.
Thereafter, 1/8/2022, it has been issued.
Yes.
Right? That's why you say.
That's why I'm saying start well limit.
Yes, first. Anything else?
So, your lordship. To that. These are all the invoices and purchase orders are all continuous process. We go on giving, supplying the orders, and it is running account, your lordship. They cannot say that is not bar by limitation because it is a running account. They have initiated so many projects. About then they have adjusted their use in other projects also, your lordship. So these are all the arbitrable questions can be decided in the arbitration proceeding itself, your lordship.
What is your response? You had issued a notice on 31st July. What were you doing for 7 years?
Because we are continuously working with
Because
them.
it's
They are,
75 years.
so because we are continue working with them, they have said that we are going to settle your dues and all those things, and they have made me to run pillar to post to take. Now at last I have to take this legal course, your lordship.
Legal course. Yes. That's it.
Yes. Judgment of the honorable.
There is judgment.
Give this petition. Yes, madam. Right. In this petition under section 11 within Yes,
For
yes,
page
one.
number, para number 13, your lords.
Full stop. On the other hand, learned counsel for respondent has submitted that the claim of the petitioner under the agreement is barred by limitation, and therefore the dispute cannot be referred to the arbitration. Paragraph. I have considered the submission made on both sides and have perused the record. Admittedly, the petitioner had invoked the arbitration clause on 31/7/2015. Thereafter, for 7 long years, the petitioner did not take any action and waited, and thereafter again sent a notice on 1/8/2022 in para 58 of so and so, AIR 2023 Supreme Court 2371, comma, in para 58, Supreme Court has held as under paragraph. Thus, in view of aforesaid enunciation of law, it is evident that the claim of the petitioner is barred by expressly barred by limitation. Therefore, the relief as sought for by the petitioner cannot be granted. In the result, petition is dismissed. Yes. Next.
Item 196,
Yes.
And presenting the counsel for the respondent, my lord. Counsel for respondent is personal inconvenience for your lordship. May have it on next Friday, my lord.
My lordship, last two occasions, they tell same story, my lordship.
Same story, right?
Yes, my lord.
So what is the agreement?
2 weeks time of time.
What
I
is
don't know the
it?
facts of
Which
the
clause? I don't, you did not know the facts, nothing. I also don't know the facts.
Well, lord.
So we are together, right? So he will tell us the facts, both of you and me. So which is the arbitration agreement?
Kindly refer page number 18 to 19 of
19/7, 1997, 17/7,
Yes,
right?
my lord. Page
Which
number
clause? Page
number 19, my lordship.
19. What is the quantum of dispute?
Last but third paragraph.
Quantum of dispute. How much?
My lordship, the respondent petitioners are purchased jointly with the.
How much amount is involved, so that we can decide whether.
Okay, my lordship. This is at 97. It's 11 lakhs 54,000 old matter, my lordship.
Old matter. Oh, this petition under 11(6).
Item 197.
Respondent in this matter, just leave it here. My lord, Sriramna is in this matter. Sriramna is unwell, requested to kindly have it taken.
No, nothing, no one will.
Is there.
Ah,
The development agreement.
all right. Parties have, same order, 4 crores. This. This 23 it's pending, Mister. What like February 23, like it's a civil suit, right? 10 years minimum it should remain pending then only. A week's time is granted to file counter failing which
Lord, coming up.
20th October. No? Next Friday is 20th October. Yes.
Lord, I am for the petitioner, my lord.
For the respondent, my lord, you have to file counter.
Nothing, no counter. What?
My lord, there is a corporate IRP.
Is it barred by limitation?
It's not.
Are you denying
There is,
then?
yes, my lord. There is a insolvency.
Document you are denying, right? So, not signature, your signature.
CIRP is pending, it is under CIRP process. IRP, interim resolution professional is appointed. IRP has been appointed in a similar case, my lord. By the order from NCLT Chandigarh. So there's a
1 week.
Yes, ma'am. We'll file a con.
Same weeks.
Please, your lordship. After the applicant, my lord.
Appeared. No.
Yeah.
Okay.
The names reflecting.
What to do?
That's the.
Probably the time is on their side. I cannot, it's 4:40. If he would have been present, I could have passed an order. Next Friday,
No, that's all great.
20th October.
That's all great.
None for respondent. No, Mark is present.
Because I'm appearing for the applicants, my lords. I filed proof of service. The respondents have filed wakalat also, but no counter has been filed.
20th October. Made clear no counter is filed on.
Senior counsel is appearing on video conference.
I am for the.
Who is appearing? Yes, respondent.
I am for the petitioner, my lord. And the respondent has already filed the counter, my lord. So we
All
are
right,
ready to argue.
20th October, 20th, next Friday. Next Friday, 20th October. Next.
I'm appearing for the applicant, my lord. Counter is already filed. I'm ready, your lordship. The agreement is at page 21, my lord. Arbitration clause is at clause number 12 at page 31.
Date of agreement, madam. Parties have entered into agreement on so and so clause. Which agreement? Delete.
Should fight under section 11.
Who appears for respondent?
I'm appearing for the respondent, your lordships.
What do you say?
I have just filed my wakalat, your lordships. Your lordships will take it up next week. I'll take
Weeks time to enable him to file counter, failing which appropriate order shall be passed. List on 20th October.
obliged.
Yes.
I think you not like Vivekananda Reddy, Ms. Lotus.
May it please your lordship. I am for the applicant, my lordship.
Respondent, no. Nobody is appearing. List on this thing, 20th. Yes, madam.
I think you not
Please, my lord. Application under section 11 for appointment of arbitrator. Yes.
Time is on their side. Next. So.
May I request 3rd November?
Acha 206, 207, 20th October, 208, 3rd November 23. None. Yes.
Time for the respondent.
None for the petitioner, so and so respondent list on. Yes, madam. Sit down.
This is a petition under section 11, madam.
What do you say? Yes.
No, I am challenging that there is an objection with respect to
20th October 23.
Your Lordship, I appeared for the applicant. Last time I apologize for my absence in the matter, my lord. Your Lordship, notice has to be issued in the matter.
So how it has come? Heard on the question of admission notice.
Deeply obliged.
Personal service, proof of service.
Deeply obliged.